ಪ್ರಾಸೆಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸಲುವಾಗಿ
ಹೇಳಿ. ಹಲೋ, ಏನ್ ಡಿಸ್ಕೋ? ಒಂದು ನಿಮಿಷ ಇಲ್ಲಿ ಹೋಗ್ತಿದ್ದ ಯಾವ ನಮ್ಮ ಇವ್ರಿಗೆ ಯಾರು ನಾವು ಮಾಡ್ತೇವೆ. ಒಂದು ನಿಮಿಷ ನೋಡಿ, ಇವಾಗ ಆನ್ ಟೈಮ್ ಪ್ರಿಂಟರ್ಸ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಆಯ್ತಾ ಜೆರಾಕ್ಸ್
Sir, total 2 sitting 10:45.
It's filed in the December first week, my lord. Complaint, the office objection, everything it is in the first week of January, my lord. Typed order sheet also typed in 11th, my lord. Still it is not posted, my lord. Last week I submit before this honorable court.
What is the
Directed
urgency?
there is no caveat, my lord.
What is the urgency?
And it's already, my lord, it is award, arbitrator award, awarded, my lord. It is set aside by the honorable sessions court, my lord. It is more than 10 years claimed amount, my lord.
Just give it after 2 weeks. Just
Your
see
Lordship,
the-
we have suit for.
One at a time. Sorry. One at a time. I'm not. Yes.
Yes, Your Lordship, we have filed 2 commercial appeal in the month of August, Your Lordship. We have cleared all the 5,000, but till today they are not posted for admission.
When did you clear it?
Cleared August, September itself, September, October itself.
They have not
cleared.
listed it?
December, one case is cleared in December and one is November.
Okay, just take it, ma'am, after
Your
this.
This is an appeal against a suit for,
One. Just see date, give the date. But see, is there any caveat?
No, cleared.
No caveat. Just list it. Check up. Yes.
yes, Your Lordship, this is a suit for mortgage redemption that was decreed in favor of the mortgagor. The mortgagee is now facing attachment of his assets in execution proceedings, which is due to be heard on the 5th of February. I had filed this appeal in September last year. Your Lordship will recall I had made a mention on Friday that the file had gone missing from the registry while seeking to comply with objections. After Your Lordship's direction, the file was found, objections have been cleared, there's no caveat. But I'm due to be heard on attachment of my assets on the 5th of February. If I could request.
The caveat or no?
No
caveat?
caveat.
When is the execution?
Execution on the 5th of February, Your Lordship.
Just take it, ma'am. Yes, any mentioning?
I'm obliged.
Explain number 17.
Okay, FPP order has been passed without considering the bill that was raised on it. There is a couple chances with the rest.
When was the order passed, final decree?
Into
Then why it's so late?
It meant, but there were some.
Is there any date given now? It's already pending matter. Have the objections been cleared? No. Are you sure? Objections cleared? No, ma'am, you will clear the objection, then mention it. Getting? What is the objection remaining? You will say so, because then when you say so, you have the remove the objection. Who? Why? This, what is this? No, just check up.
My lord.
Yes. Yes, ma'am, tell us.
My lord, these are 2 MFAs arising out of an arbitration application, an order from an order dated 5/9/2024.
Huh.
We were restrained from selling a particular property. It's been, the restraint has been done since 2012. And my client is facing a lot of issues because of that. This is a
What
date,
is what you have filed, ma'am?
we have filed an MFA in this.
The objections are cleared?
Yes, all objections have been cleared. It's a date given matter, my lord. It was given on March 3rd.
Huh.
If we want to move it earlier, there's acknowledgement from the
Who is the other side?
I've served on the other side. The acknowledgement is mentioned here.
What is the urgency?
The client is facing a lot of difficulties, your lordship.
That's no reason, ma'am.
RFM.
Have we, this court had given the date?
Yes, it's the court, the CJ had given the date in this.
Very well. You'll file an early hearing application, not in this manner.
We filed an IA for early hearing as well, ma'am.
Very well. Now, have you informed the other side?
Yes, my lord.
You will inform the date also to the other side.
Lord, we've
Just
mentioned.
take it.
RFM, my lord. Suit for specific.
RFP. Madam.
When did they initiate FTP? Then when is the date now? Have you challenged the preliminary decree? When is the date? What is the date? We'll have it on that day. Why are we let it come on that day? What are you challenging in this appeal? Final decree. Final decree made. Just take it. Any execution file? No, nothing. Just say that. Final decree file.
My lord.
Just save the serve caveat. All the respondents you have to serve and inform the date.
My lord.
So, yes. What is urgent? The proceedings are going on. Any commissioner appointed? Then don't clog. Okay. There is an urgency, real urgency. You mentioned it. We will appreciate that. What is the date now in that? So, all right, let it be February. Commissioner appoint, then get. What are you challenging now in this? What are you challenging in this? Which order? What is the order passed? Look into it very well. There must be a preliminary decree, then the final decree proceedings are going on. There is only Nate, commissioner not appointed. Are you challenging the partition itself? Check up first. We will not allow that. We will not allow the checkup. Any urgency, we will appreciate it. We will look into it. Just mention it after lunch. Have a look and then mention it after lunch. Yes. Yes. What did the 34 court do? What are you now? What is the urgency? They have filed? Have they filed? Have you received notice? For which date? Pardon?
29th February.
This month. Okay. Now, how much is the liability? Just take it, ma'am.
RFA.
We'll come back. What is yours? No, is the caveator there? Ma'am, just check up the objections. Objection complied with. Just louder. Can you switch on the mic?
RFA 441.
Non-compliance of the after subjections, my lord, same is dismissed, my lord. The stay for disposition as such, my lord.
You have filed an application for recall. Have you removed the objection now?
Yes,
All-
complete, my lord.
Just
All the
take it.
objections are complete.
Just take it.
My lord, RFA 446.
Yes, 1 minute.
Okay, wait. No.
Yes.
This RFA is already admitted and I have filed the paper books and LCR also received. Meanwhile, they have filed the execution before the court below and
What is
got
the
the
date?
attachment order.
What is the date?
5th February, my lord. Because of
Just
that.
take
there
that.
is
RFA, my lord.
Just one. Let's be through with one.
29th.
Sir.
Is the other side, the caveator there, just ask. Huh? Just ask him all objections cleared, everything. So this is a pending matter. They have to inform the others. Just ask him, just tell him. He has to inform the other side. Take an acknowledgement. All the respondents.
RFA,
You just check up, all the respondents have been acknowledged. Yes.
RFA, my lord, suit for specific performance, my lord. My lord, execution was pending before the trial court, my lord, on 30th January, my lord. 30th January is the execution hearing date, my lord. That
It's
is
coming after notice.
Yes, notice what's been issued in process also paid, my lord.
Huh.
It is for admission.
Is it a pending matter, pending RFA? Which year?
2022.
You have served the other side.
The other side is not appearing, my lord.
Have they filed? No, they have been served.
No one represented, my
They have served.
lord. The process was been paid, my lord, but
Just check up this. When is the date before the
30th January, my lord.
executing court?
Yes.
Just give it after that, not so urgency. Give it after that.
6-2. 6-2 office objection compliant.
Office objections cleared?
Yes, everything.
All?
Yes,
Yes, ma'am. Of the today's list? Yeah, just wait. Will come. Any other mentioning? Okay, call me.
Serial number 1. Shekhar Shetty.
Appearing for the appellant in this case, my lord. Serial number 1, my lord.
Yes.
Appearing for the appellant in this case. my lord.
Yes.
My lord, so we have filed a formal application for condonation of delay, my
So you
lord.
have to file it, no?
Yes, my lord.
Who has to file?
Me, appellant, my lord.
You are the appellant.
Yes,
Now
ma'am.
you have to file. You didn't file it.
We have filed, my lords.
When will you file it?
Today, my lords.
Say that if 2 weeks are granted to clear the office objection. Re-notify.
It's been filed, my lord, today.
File it, but get it listed on the next date. Just give it convenient date, man. Don't cloud.
26-3.
Grateful.
Serial
Next.
number 2. Nagaraj Rao.
I
I appeal for the caveat respondent, my lords. The sole respondent is expired on 3/11/2024. I'll furnish the details of LR's, my lords. Let him take, my lord, and take.
What about the court fee?
I'll look into the court fee and I'll pay the court fee.
You don't you just say this. How many objections? 2 objections.
Only-
Objections be cleared within 4 weeks.
Please,
In the meantime, whatever you want to
Please.
file, you file it.
please.
Next.
24-4. Serial number 3.
I'll kindly pass over the matter.
Objections be cleared within 4 weeks.
All if my lord were to recapitulate,
Yes.
in fact, all the objections have been removed. And the matter was heard in part on the previous date of the hearing. And we proposed a
Just show us
settlement.
that, man.
We proposed a settlement to,
Just show the file. But there are 3 objections.
no, court fee, only one objection was there on the previous date to attend to was the court fee.
Just show us.
I'll kindly pass over. Senior will come, my lord.
ಒಂದು ನಿಮಿಷ ಕೇಳಿ ನೋಡಿ ಸಬ್ಮಿಷನ್ ಕೇಳಿ ಆಮೇಲೆ ಮಾತಾಡಿ.
Okay. Okay, now what do you want?
No, we have proposed a settlement to buy the property. And in fact, he has spoken to his senior colleague in the bar room. And yet to reply for us. Can it be deferred by 2 weeks so that if
We
there
can
is a
defer it.
settlement,
Shall
my
we-
client would be the happiest man in
Pass
the
over,
world.
my lord. Senior, senior is
How
on the different court. He'll come, my lord.
Shall we record it that you want to explore a settlement?
Please.
Well, now let the senior come, just pass over. Call him, ask him to come.
Right, my lord.
Serial number 4. Document to take.
Appear for the.
State appeal, my lord.
What are the instructions?
They have to take the instructions and submit, my lords, because your
Yes,
lordship may
ma'am.
kindly
I need to
recollect.
get my instructions, my lord, with
We
regard.
will decide it, ma'am. Forget it.
No,
pass over.
my lord, I need some time because I've,
No need, ma'am. I don't think. We will decide it. Pass over.
Please,
my lord, just,
Tell us one thing. These are innocuous directions. What are the directions? Tell us.
this will have a ramification on the entire state of Karnataka, my lord. So
How-
I
tell us
request
how-
for, because these are not vacant posts, these are not sanctioned posts, and I need to.
What are the directions? Tell us. What are the directions?
Please, my lord.
See the directions. See direction 4.
Matter is remitted to the fourth respondent to consider, please. We
That's all.
have considered it. My submission is we have considered it and rejected. And
But
therefore,
after this, after the learner single judge order,
yes, please. And
that's
therefore,
all. Have you communicated to them the
yes,
decision?
we have, and they have filed a contempt. My-
they have rejected, my lords, on the
Yes.
ground that the appointment is not against available sanction post. Your lordship may kindly see the order, my lords, page 26.
See, we observed it on the ground
Please, my lords.
that merely there was no sanction post, but their appointment was made.
Yes.
Okay? That cannot be a ground. Now they passed an order after the learned single judge order.
Lords, they are passed an order directly in contravention to the learned single judge order. The learned
Where does
single-
the learned single judge says?
Please, my lords. You para 8, my lords.
Yes.
Your lordship may kindly come to para 8. In para 8, my lords, after 4 lines, in that view of the matter, your lordship got that?
Page 39, my lord.
In that view of the matter. In that view of the matter, the finding recorded by respondent number 4 in the endorsement dated 20 February 2023 that the petitioners have not been appointed against the vacant post is far from truth and the impugned order has been passed without application of main. I have also noticed that the earlier rejection order dated 14/11/2016 in writ petition wherein
I
the
think
rejection
then
was.
he's right, learned single judge.
Precisely, my lord. I need to make my submissions with regard to this order.
We will hear
Especially
you.
to clarify this para 8, because they have said that, my lord, if we look into it further, it goes into giving a positive direction saying it need to be regularized. And my submission is that
My lords,
the regularization cannot be done. There is a rejection already given
No,
pursuant
where
to
does
this
it say?
order.
Where does he say? I have also noticed earlier
Take
rejection.
consideration the above
Yes.
aspects, rejection
of
of
the-
the case of the petitioner for regularization on the ground of non-availability of post or not against a sanctioned post cannot be considered as a ground to reject the application made by the petitioners. However, except the above ground of non-availability of post or sanctioned post, the respondents be directed to consider.
my lords, now,
So therefore,
Now,
since there is
now tell us, do you have posts or not?
My lord, there are certain posts, my instructions, in fact, the litigation conducting officer, my lord, is unwell, so he wasn't able to come and give me the papers required. However, the oral instructions are, there are certain posts that are sanctioned and certain posts that are not sanctioned amongst these 13 respondents who are before the court.
No, posts are sanctioned means posts are sanctioned. If the posts are in existence, they are sanctioned posts.
yes.
No, my lord, but they weren't vacant at the time of appointment, the initial,
Doesn't make any difference, ma'am. But tell us one thing.
yes,
There were no vacancies at the time of appointment.
please.
You are saying there were no vacant posts also. There were no sanctioned posts also.
Certain posts were not
The
sanctioned.
fact
and
remains you have engaged them.
Yes.
Yes, yes, we have engaged.
If you have engaged them, you have taken their services for so long.
For more than 2
One
days.
minute, please. If you
please.
want to do this, please, we will adjourn it.
I'm sorry, my lords. I'm sorry, my lords. I'm sorry, my lords.
If you have done it, you have taken their services for so long. And to
Yes.
say that they would not be considered at today,
My lord, there is a history, sorry.
I'm simple. If there are no sanction posts, you will create sanction posts. Till such time you continue them.
My lord, if I may just submit. So there was the Uma Devi case. After that, we brought about the Welfare Act for daily wage workers in 2012. Now, when we brought about that act, we also called for objections. And these individuals, my lord, get covered under that act. And they have in fact taken the remuneration and the salaries entitled for them under that act already. So, my lord, I would like to put all this before your
what is
court.
the-
Give
what
me
is-
a opportunity
We'll
of
give-
hearing,
We will give-
because this is a state appeal at
We'll
the
give-
end of the day.
We will. What is the benefits that accrue to them under that act?
Under that act, my lord, when they retire, they get a 12-month salary benefit. And then for 12 months,
That's all.
that is it, a lump sum amount which is given to them.
And what happens there for regular appointment?
They come under this KCSR rules, wherein they are given the gratuity, the pension, and various other
Are they
things.
given that?
These workers, no, my lord.
So
They
then-
they have given the benefit of the scheme under the Welfare Act, which is of the year 2012.
No, there are two acts which would govern them.
There's just this act, this one particular
this
act,
act-
which came about after Uma Devi, and we had called for objection, and there was a DC rejection of their regularization in the year 2007, which was not challenged. And this has been recurring. And therefore, let me place all these facts before your lordship, because it has a checkered history.
Very good. Okay. Just then what will you do? You have filed the appeal is yours.
Yes, the
So you
appeal is
must have
mine.
sa- You must have said so in your appeal,
Yes,
all these
my-
things.
Yes, I have, but there are certain things I need clarifications from the department, and
Very-
therefore I'm
Very,
seeking for.
at the request of counsel for the appellants, re-notify on, and they are continuing today.
Some of them have already retired.
We have attained superannuation pursuant to passing.
They attained
That
the
is
age
the
of.
order of the learned single judge, that because they have attained superannuation, the writ petition would not suffice for consideration.
But they got the benefit under the new act.
Under the Welfare Act, yes, they have received that
Lords,
benefit.
in cases where they have retired, my lord, subsequent to filing of these writ petitions, they have attained superannuation subsequent to filing of, then they will be
But
considered
there
as
are
deemed
things-
regularized.
Please,
You could not have invoked the same ground today, at least going by the submission which both of you have made, you have invoked the same ground that their appointment, initial appointment was not against the sanction post.
please,
That's right.
yes,
You could not have done that when there is a finding against you by the learner. You may, for certain other reasons,
Mm.
could have rejected it, but not on this ground.
therefore, my lord,
Now, what we are putting is possibly you must take instructions.
yes,
Now, what we are putting it to is, could you have done that? You could not have. If not, what do you intend to do? You want to recall that order, withdraw that order, pass a fresh order in terms of the order of the learned single judge. This is additionally, we are telling you, so that you can take instructions. Otherwise, there is a clear bar in terms of the order of the learned single judge.
please, let
Why
me,
we are saying is, it is not your case that without implementing the learner single judge, you have approached this court, challenging that direction. But rather it is your case, we have implemented the order of the learner single judge.
right,
In that manner, what you have said, that there were no sanction posts when their appointment. Whether you could have done it contrary to what learner single judge has said. And can we take it as a compliance? We cannot. Take
precisely,
instructions.
yes, precisely, my lord,
And after, my lord, after filing of these contempt petition, my lords, they issue this impugned endorsement, which runs directly in contravention to the finding of the learned single judge, where he said you cannot do it. First, the issuance of this endorsement itself amounts to aggravated contempt. Thereafter, my lords, when I move for this contempt petition, after more than 5 occasions, they file this writ appeal only to circumvent that the orders of the learned single judge are not complied.
At the request of counsel for the appellants, re-notify all. How much time?
my lord, second week of February, anytime.
Just give it second week of.
One more small submission, lords, if your lordship permits. My lords, the endorsement itself says that all other 3 grounds which are required in the Uma Devi's case have been complied. Even in the first round, my lords, when they rejected my case, all other 3 grounds had been complied.
What are the 3 grounds?
My lords, one, they should have worked continuously for more than 10 years. They should have been worked without the cover, interim order of the court order. Then they should have required qualification at the time of their appointment. All these other 3 criteria we have complied. So far as sanction post is concerned, my lords, recent judgment of the Supreme Court says, having extracted the work for more than 2 decades.
But we have told them.
Yes, my lords.
And mind it and say so if there are no sanction posts or there are sanction posts, what do you intend to do? How do you intend to fill up those posts? You're getting, there are sanction posts. According to, there are no sanction posts even today.
There are a couple of sanction posts but the issue, my lord, these respondents have already retired.
No,
So
at least those who are in place, no?
all of them have retired.
Everyone.
Subsequent to filing, my lords, even in those cases where they have attained.
No one is working.
Lords,
Yes,
no.
that is the observation of the
I'll take
learned single
instructions, my
judge.
lords.
See, you must take it in the fact situation when they got.
My lord, some of them are working, I'm sorry.
When they have
Because-
got the judgment of the learner single judge in their favor, what is the way out? See, you must, if that is so, then today there is no requirement for sanction posts. You are not regularizing them today. They are not there in place.
Right.
They have to only give what would be the post-retirement benefits they
Yes.
must get.
Precisely, my lord.
You're
Let
getting
me-
the point?
Yes, yes.
You must
Yes.
take instructions on
Yes.
that.
Yes, I would require
ಸೆಕೆಂಡ್ ಕೋರ್ಟ್ದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ ಯಾವುದು?
Memo of parties be made by the counsel for the appellant. Okay, applications disposed of, list this appeal, just have it in February.
24-2.
Much of it.
Next.
Serial number 8.
Lordship,
Srikanth.
for the appellant in this matter, Lordship, kindly have it on day after tomorrow, Lordship. Some document I don't have available in Lordship.
It's a pattern matter.
Yes, your Lordship.
No.
Only
we'll
one
hear it.
document, your Lordship.
We will hear it.
Lordship,
Pass,
kindly have it on tomorrow.
pass over, please. Where is the counsel who argued on that day?
Your Lordship,
Sorry, pass over.
Lordship, kindly have it tomorrow.
We'll hear it.
Tomorrow, your Lordship.
This is not the way, please.
Please.
The counsel argued, we heard the matter at very length,
Yes, your Lordship.
and he said just sought a day's time. And we don't like this, the counsel not being here.
Your Lordship is available. One document is not.
We are passing over, ask the counsel to come.
Serial number 9. Shri Nagarajappa. 9.
Appearing for appellant, Lords. Lords, I am filing the memo for withdrawal, Lords.
9, you want to withdraw?
Lords, since as per the instructions I got, appellant has got other benefits, it seems, Lords. Hence he don't want to press this matter.
Just say this. The Learner Counsel for the appellant has filed a memo for withdrawal, which reads as under, the appeal is dismissed as withdrawn.
Serial number 10. Serial number 10.
My lord, appearing for the appellants in the matter, my lord. On the last occasion, my lordships requested me to find out from the CBSE department whether the application of the respondents has been considered, my lord. My lord, the inspection has been conducted, my lord, and the present matter lies before the affiliation committee, my lord. My lord, stating this, my lord, I would like to bring some facts on record. It's a matter of policy that CBSE challenged the initial order, my lord, by the learned single judge in WP 2599 of 2023, my lord. It's to deter the behavior of this school as well as other schools to admitting students into ninth standard. My lord.
Tell us one thing. After the
Yes, my lord. WP
But you
899.
have carried out inspection even against the second order.
Yes, my lord. It's not yet affiliated, my lord, and they're still admitting students into the ninth standard, my
That's a
lord.
different argument. But what has been said, what we are informed is after you have passed this order, he has challenged it, there was again a remand,
Yes,
My-
and you have carried out the inspection thereafter.
yes.
Yes, my lord.
So whatever is the inspection report, you will pass a final order.
Yes, my lord. Kindly please give us a date.
We are
my
only
lord.
saying this, ma'am. This
Yes.
appeal has become infructuous. That's all.
I filed a memo also last date of hearing, my lord. I produced the copies also. Copies passed to the.
Just say, what was the last order? ma'am? Just say this. The learner counsel for the respondent has filed a memo. Mr. Learner counsel for the respondent states that after the impugned order was passed, pursuant to the impugned order, affecting the application of the respondent challenged before the court in petition number 8992 of 2024. Which also came to be within 4 weeks to stop according to the learner counsel for 12/8/24. Inspection has been carried out by the appellants. So according to him, insofar as this appeal is concerned, the same has become infructuous.
My lord, kindly grant us liberty to file an appeal on the second order, my lord. Of
No
WP.
need, and when it comes,
Yes,
we'll
ma'am.
do one thing. After this. Just say that the learner counsel for the appellant says that the present appeal has become infructuous. From noting the aforesaid facts, we agree with the submission made by the learner counsel for the respondent. So far as this appeal is concerned, because of the subsequent developments which have taken place, taken place after the impugned order has been passed, this appeal has become infructuous and it is dismissed as such. Okay. Take this and then.
Seal number 11, Sridhar Kishore.
Lord, this matter, the party is already taken in safe
to engage another counsel. The party himself came to the chambers and received the NOC. All the papers.
Yes. Tell us. You should have told the appellant, to be here present in the court.
It is,
Inform him about the listing of the matter.
I'm not aware as to if it was informed today, my lords. It is.
Otherwise, what will you do then? We have to, we have no issue. We'll adjourn it.
Lordships may have adjourn it, my lords. I shall inform the.
What remains in this? We don't know.
All the papers were taken back from the appellant. I have no instructions or the
He
papers.
has taken the brief from him.
He's taken the brief, man.
We will do one thing. We will just adjourn it at your request, inform him about the date of hearing. If he doesn't come, we will take it further.
Please.
Just say this, the counsel for the appellant states that the appellant has taken the brief from him and that's it. And it appears that he intends to engage a new counsel. In noting the said submission, re-notify, just have it next week.
4-2,
Please, my lord. Oblige.
serial number 12. Hemant Reddy, 12. Serial number 12, Hemant Reddy.
So I'm for petitioner, that's objections, the typed copy is not, we have produced a translated copy of the annexure F and G.
But what do you say on the order? Impugned order, what is the difficult, this thing?
You see, in the impugned order, that appeal is filed, the writ petition is filed, suppressing the arbitration appeal. AA 7/2015, that was dismissed, So there, they have to file appeal against that order under section 30.
Appearing for whom?
I am appealing for a petitioner, special land acquisition officer.
So you were required to, then why did you file this appeal?
Means after the dismissal of the arbitration application, they suppressed it and filed this writ petition. They have the option to file appeal against the arbitration order of the district judge. But they have not chosen for that. They suppressed that, they came before this court with the writ petition.
What happened to 34 petition?
34 petition was dismissed.
When? On what ground? On the ground of maintainability.
No, it was. Petition was filed by them, that was dismissed. So it was dismissed on 24/11/2015, that page 170 to 174 in the our petition.
That was, see, the learned judge says it is not maintainable, he is wrong. He may not be correct. And that's what the writ petition say. The writ petition says that the 34 was maintainable.
Yes, 34 was maintainable, but against this order, they have to file appeal under 37, section 37.
Where is the order under 34? The 34 says it is not maintainable. He filed a writ petition, rightly so. 34 was rejected, not being maintainable. He could not have filed 37. And 34 itself was not maintainable. 37 would not be maintainable. He filed a writ petition. The writ court says 34 was maintainable. So he should have gone back. And that's what the learned single judge says, that the delay would not come in the way. And it should be decided on merits.
Yes, both filed.
But why did you file? You filed. You should not have filed this.
No, against the order in the petition, we have filed.
Which order you have challenged? You see which order you have challenged?
Challenge is the annexure A order.
What is annexure A?
Annexure A is order in petition number 23611 of 2016. In a para 4.
You should not have challenged it. How are you agreed by this order? He says 34 is maintainable, go to 34. That was not a direction to you. That's a direction to the other side. Respondent number 1. Okay. So better would be that you should not. You must withdraw this. Did this gentleman Sanaya, has he revived that 34 petition?
No, not till, not,
Have you received notice?
not.
Very well, but you must withdraw this.
So one date may be given.
Oh, this is an office.
Ah.
But they have to show legible copy of it.
We have filed a translated copy. It is Kannada document. We have filed it.
You must withdraw it.
Date may be given.
Just think over it, you will pass over. We don't want that. Otherwise, this, you should not have filed this appeal. Okay?
So one date may be given. We will file memo. We will file memo for withdrawal.
One memo, just think over it, we'll pass over. We'll take it. Pass over.
Bill number 13, Srinivas.
Lord, I prefer petitioner. I'm sorry, appellant. We are compromising the matter, my lord. May I just hand over the compromise petition, my lord?
You've done it.
Yes. I'm handing over the DD to. I'm handing over DD of 27 lakhs to him, my lord.
That's final.
Yeah, that's final, my lord. That's the final payment. Where are the parties? Parties are before the court. My lord. May I just.
Okay, this shows. Just say this, limits. Counsel for the party is by show the CPC.
What is 23, Allah? 23. It should be 23, my lord. By mistake, it's 33.
Or maybe I am wrong and she just corrected.
Yes, my lord, I'll just correct it and I'll.
Ask them to put signatures.
I'm sorry, my lord. No, I didn't.
Not much of a difference. Phonetically, both are same, 23, 23. But the only thing is figures.
Twenty-three ago, 33 ago.
Settle the interstate dispute. The terms of the settlement as noted from the memorandum each September. The councils as well as the representative states that the party shall be bound by the terms of the settlement. The statement is taken on record. The learned counsel for the appellant. What are the details?
It's on demand pay 27 lakhs
You want
only.
to give the details, give it in writing so that we can.
My lord, it's already there in the compromise petition.
DD bearing 0058. It's 16/1/2025. The counsel for the respondent who in turn has handed over the same to the. He's the proprietor.
Yes.
Good name?
Krishnamurthy.
V. Krishnamurthy. Okay, the appeal is disposed of as settled. Memorandum is also disposed of.
My lord, court fee, my lord. Since it's for the first time. For
The appellants.
to the
To the appellants. And.
I'll furnish my bank details, madam. I may be permitted to furnish the bank details of the appellant so that it can be transferred.
We will work it out. We will work it out. To the appellants.
Much,
Thank you.
much.
Thanks.
14. Serial number 14, Shri Mahesh Chandra.
Sorry, I appeal for the. Appellant,
I'm for the respondents.
This matter, my lords, was moved. It's a fresh matter, my lords. The one office objection is one of the defendant, my lords, and the respondent here has passed away, my lords, and they're asking for a death certificate. My lords, we do not have that.
Fine.
My lords, it was not reported to us, my lords, when she was placed ex parte, my lords, after that.
Who appeared for this respondent before the trial court?
My lords, she was placed ex parte, my lords, since beginning, and thereafter it was reported that she passed away.
What is the date before the trial court?
Today, my lords.
What is the stage now there?
My lords, it's in the cross-examination stage. I am not seeking for stay of the proceedings, my lords. What I'm seeking for is a stay of the order, my lords, which is impugned before my lords.
What remains there?
My
It's
lords,
as good as appealing, allowing the appeal.
my lords, may I make this request. The application was filed by respondent number 1 to 3. My lords, when I moved the matter before my lords had directed us to serve a copy, intimate the opposite side, and my lords come before my lords. Now, my lords, we have served the copy, my lords.
My lord, the copy was served only on Friday
Yes, ma'am.
evening.
Why
Your
don't
Honor.
we moved it?
For who?
Respondent,
Which respondent?
respondent number 1 and 2 here.
You are the contesting respondent.
Yes, Your Honor. We undertake to file the wakalat as well as objections, Your Honor. Only after that it may be taken up for hearing on merits.
Who appears for respondent number 2?
Lords, they have not filed any application, lords. There are other counsels who are appearing.
They have filed the application.
They have filed the application.
They are the contesting.
They are the contesting parties, my lords, so far as this application is
Ready to
concerned.
argue?
No, because we were intimated only on Friday evenings.
What will happen today before the trial court?
Let them continue with the cross-examination, my lords. Our only request is that, my lords, the entire application may be heard, but let them continue with the cross-examination on the pretext of they're not doing so.
We want.
Second week of February.
We'll have it on second week of February. Just say that it is agreed by the counsel for the parties. Now, what we are recording your statement also and yours also. The respondent number 1 is the contesting party.
1 to 3, my lords. 1 is the company, 2 and 3 are the directors of the company. my lords.
That's what we are asking you. Are you appearing for 2 and 3 as well?
Yes, yes, yes.
So we take it, but who filed the application? The company?
It was
only?
respondent number 1 to 3, my lords.
All 3 together?
Yes.
Say that 1, 2, 3 respondent, 1, 2, 3 are the contesting parties. According to the Luna Council for the appellant, the objection of the registry insofar as respondent number 4.
No, that's, we have not named them as respondent also. Okay, yeah, we have, I'm sorry. That is, that's Mrs. Kavita Wagnare.
Respondent number 4, namely Kavita Vadmare, who has since expired.
Yes, ma'am.
Was ex parte before the court below.
Yes, ma'am. That's
Ex parte was court below and is not the contesting respondent for the purpose of this appeal.
absolutely
That's right.
yes.
Now, 4 also.
4,
Four,
5,
five,
6,
six,
7,
seven.
8. They are not contesting qua this application, my lords.
For the appeal.
Yeah, qua the appeal. So my lords, notice may be dispensed with insofar.
Also states that even the respondents. Why did you renumber it? Acha Kabata Magwar.
Yes, my lords. So that they had to, my lords, the office insisted that we had to renumber them, my lords. So we did so.
Even other respondents, namely Mrs. Vasudha Shinoy, Messrs. Viva Info Solution, Messrs. Explonet Solutions, Mr. Sudhanath, and Mr. Rajat Gowda are also not contesting respondents for the purpose of this appeal.
Please, my lords.
In other words, it is his admission that this appeal is primarily directed against respondents 1, 2, 3. If that be so, the notice to the other respondents is dispensed with.
Great.
At the request of counsel for the respondents 1, 2, 3, give it in second week of it.
My lords, may I request this, my lords, may ask them to go ahead with the cross-examination in the pretext of.
Let it be next year. Today they will be cross-examining. They may not be completing it today. Possibly both of you.
It's for further cross-examination, my lords.
You will take a date beyond the date which we have fixed.
Then my lords, may I request, my lords, may have it in the first week of Feb. Then the reason, my lords, this petition, my lords, is of 2018, and my lords, from then, my lords, till date, the object of the Commercial Courts Act, my lords, to expedite any trial itself.
1 week make any difference? Could not have it after second week.
Lords, may I have it on 10th, my lords,
Yes, yes.
week starting.
Just see the date. Please,
13 to
13. Okay. Next.
obliged. 15.
The matter pertains to manage the acquisition of the land by the National Highways Authorities for the expansion of the land. Expansion of the road in question.
We have not filed reply, ma'am, to the,
Will file, Nala. We will file, Nala.
who appears for the, is it NHA?
But last time they appeared, minute, they saw time, minute. To file objections on.
Try to IA number 1 of 24 and 3 of 24. Be filed by the counsel for the respondents written in the law.
Represented.
Counsel for the respondent number 2, B5, respondent number 2. B5, within 6 weeks, we joined up within 2 weeks thereafter, this time.
21-4. Serial number 16, Shri Murugesh Charati. 16.
21.
They appear for the appellant in the connected matter.
State Melo.
I pay for respondent matters. In the first of them, there are 4 connected matters. In the first of the matter, rank number respondent number 2. In the other 3 matters, rank number respondent number 1, same person has expired ballots. In first, second, third, and fourth matter, I am appearing for him. I filed application by Ellas to come on record and prosecute on his behalf. In the second of the matters, he is yet to file, but the same person. Appellants may be directed to, we have already served them a copy. They may be directed to just amend the cost title, and if my lords permit, we may be permitted to come on record and prosecute.
Expired.
One Uma Shankar, my lords, respondent number 2 in the first matter.
Respondent number 2 in 82.
Please, my lords. In the other matters, he is respondent number 1.
He is respondent number, namely Uma Shankar.
Please, my lords. He expired on 1/1/2025.
You have filed, now this is also the respondent in 16.3.
Please, my lords.
Now you have filed application in which matter?
It's in first of the matter, third and fourth matter. First and point 2 and point 3. I am appearing. My learned friend is appearing in 16.1. He is yet to file, my lords, but it's the same person, so I am requesting that the common order may be passed, my lords.
but I have not received the copy of the application, my lord, in any of the matters. I am the appellant, my lord, in the connected matter, my lord, WA 559 of 2021.
That is a matter, application is not yet filed. We will, he will serve it, my lords, but it's the same,
16.5, no application filed.
but 16.
16.1 or
16.1 application is not filed, but it is ready and yet to serve. In other matters, we have served the appellants and it is already filed.
So in other three, you have filed it.
Please, my lords. In 16, 16.2 and 16.3, I am appearing, it's filed. 16.1, it is ready and yet to file.
You filed it, give it to him the copies.
Please, my lords.
Now, who appears for the appellant in 16? You appear, ma'am? Now, who appears in 16.2 and 16.3?
16.3, my lord, I am appearing for the appellant. We have received the copy, my lord.
What about 16.2?
That's one. Krishna Rao appears, my lords. He is also served, my lords.
Just serve a copy to all of them.
It's, please,
I've
right.
been informed that the Pavan Kumar will respond in number 2 in WA 582 of 2021 and respondent number 1 in all other appeals, connected appeals has expired. The counsel appearing for the counsel who appeared for Uma Shankar states an application bringing the LRs has been filed in 58221, 900 of 21, and 826 of 23. It also states that the similar application shall be filed in WA 559 of 21. If that be so, directing the counsel to serve a copy of the application on all the parties appearing in this batch of appeals. Okay, within 2 weeks, granting liberty to the parties to file reply, if any, to the application on or before, at least 1 week before the next date of hearing. We notify the appeals on
21/4.
May I request for a shorter date, my lord? Very old petitions, my lords. I am the
24/3.
obliged, my lords.
Lords, seeking 2 weeks' time, this advocate's on record, his mother is passed away. We've intimated the other side on Saturday over email.
it on behalf of the council for the action. We notify.
20th March,
Obliged.
18. Still number 18.
Lord, the petitioner. On the last occasion, Lord said permitted us to file not a calculation. Yes, pass on. It should be 2, no? Apologies. Lord, the issue, Lord, relates to, Lord, the calculation that was not made out, Lord, in the earlier order. But can I just request, Lord, to please turn to, Lord, the commercial appeal that was filed by the bank. Just to give a background, Lord, I am the landlord of the property. But my,
We're ready to argue.
please, no.
We'll just pass it.
Please.
19.
For the respondent 119.
For the appellate. That's.
Yes,
The appeal could be taken for disposal. So I'm ready to address my arguments.
pardon.
It may be taken for disposal. I am ready to address my arguments on main.
Okay.
Please, Mr.
20.
My lordship, I am for appellant, my lordship. The LR's application is pending, my lordship. The respondent had filed already LR's application, my lordship. To yet to consideration my LR application, my lordship.
Since 1947, we are in the house. 1947, we are in the house. They have not paid us, given us.
That's what I'll argue, my lordship. Today is to.
The internal advice, my lord, is to give her the land.
kindly, order may kindly be looked into. Almost last 70 years we are residing. They say you have not constructed the building when it was granted. We are, last 70 years we are there after constructing the
Now
house.
we were saying that they pay to the respond to pay as for this present market value, my lordship. That is only issues, my lordship. They have violation some of the sale agreement. You have only executed a sale agreement, my lordship, not the sale deed, my lordship. Therefore, my lord, the single judge to order that to execute the sale deed, my lordship.
Who has expired?
The respond, my lordship.
Which respondent?
Only one respond, my lordship. Only one respond. He has already did, my lordship. That I have filed a LR's application, my lordship. Yes, my lordship.
Writ petitioner has expired. His son is on the file writ appeal. Sorry, made party.
Already filed LR's application that
Writ
has to bring
petition
the
on behalf of the joint family filed writ petition.
No, you appear for whom? You appear for whom?
respond, my lordship. Is appearing respond, my lordship.
I appear in the contempt petition. This IA is not allowed.
The same, they may have, we have challenged same writ petition. That's what they are clubbing with the two other, my lordship.
You appear for the contempt petition. For whom? For the Ishwaraya.
Yes.
You appear for the
I am appellant only, the first writ appeal, my lordship.
The appellant is this.
BBMP, my lordship.
Bangalore Mahanagarapalika.
Yes, my lordship. Yes, my
You
lordship.
appear for them.
Yes, my lordship.
And who appears for the respondent in the writ appeal?
My lord, Naveen Ishwaraya is the son. He, with the permission of the court, he has filed writ contempt petition because
You appear for the respondent in both, na? Writ appeal and contempt.
yes,
Now, has he expired? Ishwaraya.
Ishwaraya expired. His son is on the record.
No, is he on record?
Yet to come to record, my lordship.
Just say this, this is an application. This is 6/24. Is this? Acha. Say 4/24. Then 5/24 and 6/24. These are three applications seeking continuation of delay in filing the application to bring the LRs of the deceased respondent on record for the reasons and comma, semicolon, for setting aside of abatement and from bringing the LRs of the deceased respondent on record. For the reasons stated in the affidavit in support of the prayers in the application, comma, they are allowed, all are allowed, all the applications are allowed. The delay is condoned, the abatement is set aside, and the LRs of respondent number 1, namely Naveen Ishwaraya.
Yes, my lordship.
Yes, Naveen Ishwaraya.
Ishwaraya is brought on record. Let amended memo of parties be filed in writ appeal 443 of 2023 and necessary corrections be made. Suffice to state, Naveen Ishwaraya is already a petitioner in contempt petition. Hence, no change, no amendment to the memo of parties is required. List the writ appeal and the contempt petition for hearing on
3rd of March.
Later.
What are these?
Not.
So, okay. What we have disposed of 2, 3, 4, 5.
Correct. 4, 5, 6.
So 1, 2, 3 are not pressed. 1, 2, 3 are dismissed as not pressed.
3rd March.
Contempt petition also may be same day.
Same day.
Till number 21. 21.
It's a commercial decree appeal.
Yes.
There's a delay of 23 days. I am for the respondent.
Who has filed this application for release of the amount?
I have filed the application. Pursuant to the stay
Where are
granted
the-
by this court,
Where are the appellants?
they have not filed any appeal, objection.
Pass over, just
Okay.
pass.
Shri Ravi HK.
Hey, please, ma'am. And this first appeal by the defendant number 7, my lord. The trial court has declared the suit, my lord, for permanent injunction and
Just say the-
declaration, my lord, declaring that the sale deed executed in my favor is not
Sure.
binding.
You appear for all the respondents?
You know, I represent for respondent number 1, so Lord's Miller.
Just not issue.
That is respondents.
See, we'll issue
1 to
notice.
4 Miller.
We'll issue notice.
For other respondent,
You appear for whom?
1 to 4 Miller.
1A to
1A to the respondent is 1 to 4 here. And plaintiffs 1A to 1D.
You appear for Bhushanam.
Bhushanam's LR.
Original plaintiff.
Just say the notice, so and so accept notice for
The alerts of the plaintiff, that is
that
respondents
of
1 to 4 Miller.
Messrs. Bhushanam, respondent. 1 to 4.
Yes.
1 to
4 Miller.
4.
Yes.
Who appears for this 5?
Miller, they are all
Let notice be
defendants who
issued
did not
to,
contest the case at all.
let notice to issue to 5 to 10.
But I think it may not be really required because the other defendants may not.
No, if he says so, then we will dispense with.
I think that should
Do
be,
you require notice to be issued? Ma'am, just-
because they never contested the suit.
Do you require notice to be issued? 5 to 10?
5 to 10, my lord, it may be dispensed with, my lord.
We don't know. You have to take a call.
Lord, they were served before the trial court.
But were they appearing before the trial court?
They did not appear, my lord.
So if you will record your statement,
Yes, sir.
they were proceeded ex parte.
No, they had engaged lawyer, but they did not contest the case.
No, if you want, then we will record that.
Lord, I think better to issue notice also.
Issue notice 5 to 10, returnable on. Just say that trial court record be requisition. Are there any proceedings pending?
The execution case has
is
been
there.
already filed.
Execution is there, it is set down tomorrow.
The execution case is filed. We have taken possession of part of the premises.
They have sought.
Taken possession.
We have taken possession
No,
of part of the
Not,
premises.
not so far as the property in which I am in possession, they have sought for delivery of possession.
But have they initiated against you also?
Yes, Miller.
Yes, yes,
Though, but that possession is still with them.
yes, my lord.
Portion of it.
Portion of it.
Their prayer is for delivery, yes, yes.
But is it in the complete possession? The property is in complete possession of the appellant? Or
Not
part of
complete,
it?
a
Only
part
part.
of it now, as on date, Miller. Because what has happened, we have taken a portion of a part of the premises. And one more aspect is, the appellant before your lordship is a pendente lite purchaser.
Is?
Is a pendente lite purchaser. And the persons who really contest, who were against whom I had filed the suit earlier, defendants 1 to 4. They have in turn sold the property during the pendency of the suit to defendants 5 and 6. From them, he has purchased the property. That is the scenario.
Very good. We say nothing on this.
Yes,
Let
ma'am.
notice be issued.
Yes, ma'am.
And we only say the trial court record, we can requisition. It don't, you have only filed the execution, huh? No
Execution-
proceedings are pending before the court concerned. Only executions are pending.
That's correct.
They have sought for delivery of possession so far as I am concerned.
No, we wanted to call for the record, no? Trial court record.
In the
the
meanwhile,
requisition
let
before.
them not,
What do you say on that?
Lord, your lordship may call for the records and hear the matter that yes.
That's
Till
what
then,
it-
of course.
No,
Miller.
till the next date of hearing, would you be
Yes, ma'am.
insisting upon?
Your lordship may pass in order. Miller.
Saying that status quo as of today,
Yes, Miller.
with regard to possession,
Yes, Miller.
title is also with them.
No, title, we are the owners
I am
in
the
our specific
purchaser.
case. He has purchased the property during the pendency of the suit, Miller.
So
I have
we-
been declared to be the owner of the property.
Yes,
to the
we
trial.
just say status quo. The status quo as of today with regard to which part of the property?
Two shop premises has been taken possession in the execution proceeding.
No, what is they are in possession of?
Hind portion of the property.
How would you describe that scheduled property? Is there any way to describe it?
No, your lordship may refer that two shop premises are in our
No,
occupation.
then we will say only schedule, the status quo with regard to scheduled properties with which the appellant is
possession.
concerned.
Not
The,
concerned.
no, scheduled properties of which the appellant is in possession.
That hind portion of the property.
Hind portion of the property.
backside portion.
The backside of the property.
There are two shops in the front portion, my lord. We have taken possession of the shops.
And what about what is the backside?
Backside portion is a residential house,
It's an office.
office premises.
Office. A passage.
Let's see that we should not want any
Yes, my lord,
confusion
your lordship.
later.
And
How
as
would
it
you-
is
how would you
described,
describe the property?
my lord, in this plain schedule, we have described it as a property measuring 1,550 square feet with a built-up area of 600 square feet.
Where are you
In
reading?
the schedule, my lord, suit schedule, it is there.
Okay, let's see that.
Page number 124.
Page number 124, my lord.
The right to enter India.
One,
The email is there.
124, you said?
Page 124 of the paper book, my lord, appeal papers. That is a decree of the trial court, my lord.
Page number
Page number 124, my lord.
1 to 4.
124, 124.
This is a valuation.
Schedule, suit schedule property has been described.
It's 122.
Huh.
This is-
Lordship.
So shoot schedule property is this.
Yes.
So status quo with regard to property bearing number 409 situated at Domlur Extension, Bangalore, measuring 50 into 30, in all measuring 1550 square feet, together with built-up area of about 600 square feet, with RCC roofing, red oxide flooring, here described everything. Jungle wood doors, steel windows, with all civil amenities. That's all?
Yes, ma'am.
Any other description?
That's all, ma'am. And in this, your lordship may say excluding two shops, which we have already taken possession.
Excluding two shops.
Two shops.
Excluding two shops, of which possession has been taken by the respondents.
1 to 4, ma'am.
1 to 4. That's right?
Lord, according to me, Lord, we are in possession. They are saying that they have taken it. We are in possession of the entire property.
Entire property.
Delivery warrant
those
has
two
been
shops?
issued.
Including those two shops?
Yes, according to us, we are in possession, Lord. They
No,
are-
ma'am.
they-
Delivery
the last
warrant.
may say,
has
Lord,
been
we are in
placed the
possession.
papers also, my lord. Delivery warrant is.
The last may
been
say that the
executed.
property in possession of the say appellant.
They are going to create confusion, my lord. My submission is, in the execution proceedings, there are documents to
Why
indicate.
don't you take instructions? Are the shops in your possession or not? Then it will be again the same,
You last may say, Lord, excluding two shops.
excluding
Yes.
two shops. So that's the instruction.
Yes.
huh? Very good. Excluding two shops till the next date of hearing.
A date may
Right.
come.
We are fixing it.
Grateful.
24/4,
24.
4/4, sir.
Ma'am.
Interim order, no? See from page 122. 23.
23,
Please. This is a appeal by the defendant, my lords.
They say issue notice.
I pay for the respondent bank, my lord.
Yes,
My
how
lords,
much deposit?
my lords, the reason is that, my lords, the very suit itself is not maintainable because it was a purpose for the agriculture loan. And the mortgage deed, simple mortgage deed was executed for the purpose of agriculture. And the loan availed was 3 lakhs, my lords. The suit was filed for 13 lakhs 49,000. And the suit came to be decreed. And this
But
appellant
then
was
in any
placed.
case, then we'll simply issue notice.
Notice has been issued, my lords, with respect to respond number 2.
To
And
show us.
respondent number 2 is the co-obligate one. And he's a respondent 2 is the co-obligant to the loan. Only respondent number 1 is only main person, my lord.
What do you say on respondent number 2?
My lords, he was a guarantor, my lords, he was a co-obligant along with me.
He's served, yeah? Served. He is served.
Please. That was
They say that respondent number 2 has been served despite service. There is no appearance for respondent number 2. Full stop. Let the trial court record be requisitioned. You have filed any execution?
No, my lord, execution has not been filed, but that
The petitioner was the ex parte. He did not appear before the court also. Now the petitioner is contending various agriculture loan is a commercial court has no jurisdiction and all, but they are not appeared at all. Both the respondent 1 and 2, they are not appeared for the order, my lord.
But tell us one thing, please, how would you come over this delay? Show us the application for delay.
My lords, the delay was, my lords, he was ill well for 6 months, my lords, because he was suffering from spine problem.
Let's see that.
That was stated in my affidavit, my lords.
Where are the documents?
I produced the documents because he was under the Ayurvedic treatment, my lords, because since
Please show us the documents.
I have stated in my
You
affidavit.
must support your application now by and mind it, we are in a commercial appeal
Please, my lords,
and the limitation is very limited.
please, my lords, I do agree.
So how would you come over? These are 294 over and above 60 days.
60.
Law is very clear.
And he was illiterate, my lords, he was.
No, we want to see all the details, please.
Please. Produce that document, my lords, to show that.
And this is very vague, your affidavit. In fact, this doesn't really give any reasons, except serious ailments.
Will supporting, I'll file a better affidavit also, my lords, along with the documents, so that my lords may accommodate me time.
Just say this, this appeal is barred by 294 days delay. We have perused the affidavit in support of the application. To stop, the same does not disclose justifiable reasons filing the appeal after 294 days. So learned counsel for the, and in fact, we've also find no documents for even with regard to the serious ailments from which the appellant was suffering from have not been annexed. Learned counsel for the appellant seeks 3 weeks' time to file a better affidavit and closing therewith the relevant documents. So noting the said submission, re-notify all. But first you will say respondent number 2 is served. That you will say.
25 to the number 24.
I appear for respondents 1, 2, 3. I request for my lords a short adjournment in this matter. Because my lords, I intend to file my lords objections to the IA that they have filed my lords seeking production of additional documents. But those documents, my lords, are fabricated one because I have verified and I have made my lords necessary application to secure those documents, my lords.
You appear for whom?
I appear for respondent 1, 2, and 3.
For the
Private parties.
private parties. 1, 2, 3.
Please.
What about the others? 4, 5, 6, 7?
1 to 4 state, my lord.
Huh, pardon?
1 to 4 is state, my lord.
Ma'am, 1, 2, 3 are private parties.
1, 2, 3 are private parties.
Rather 4 and 5 also, 6 also.
6, my lord, we have sought for dispensation. We have filled a memo, my lord.
88.
To only 6 or?
6, my lord, only 6.
And what about 7, 8, 9, you must be appearing?
Yes.
7, 8, 9, 10. Now, what do you want now? Tell
Lords,
us.
I need an adjournment, my lords, to file
7.
objections. And I'm intending to file, my lords, one more IA to seek, my lords, producing, my lords, certain additional documents on record.
Are you a party in the connected appeal?
Please, my lords.
Huh?
I am a party, my lords, in the connected appeal.
What is your status there?
6, 7, and 8, my lords.
Just say that counsel for the respondents 1, 2, 3 in writ appeal 622 of 2024 and respondents 6,
6, 7, and 8.
6, 7, 8 in writ appeal 688 of 2024 seeks an adjournment. What do you want? Why you want to file any additional documents?
I want to file additional document as well as, my lords, objections to their IA.
As he intends to file additional documents and also reply to which IA?
Lords, IA, my lords,
2/24.
IA number 2/24, my lords, seeking production of additional documents.
2/24. So also 2/24 in writ appeal 622 of 2024. The reply be filed within how much time? 4 weeks.
Please.
Rejoinder 2 weeks. List the appeals for hearing on.
16:4.
Please.
For the dispensation for us.
Where is that? This is a memo filed by the appellants, by the advocate for the appellant seeking dispensation of notice to respondent number 6. Why do you want dispensation, Mr. Hola?
Yes, sir.
In
In fact, he had also challenged it along with us.
Oh, they are part of the appellants?
Yes.
There's only one appellant, Mr. Hola.
No, appellant here, but they had, my lord, earlier, my lord, in the writ petition. Writ petition papers.
Jointly granted.
It was jointly granted to us. So, my lord, because they could not come, my lord, we have, in fact, we can even transpose them. Transposition.
To just say this on the ground that the appellant herein has not claimed any relief against the respondent number 6.
Correct.
That is Chandrappa and his legal heirs in this appeal. Full stop. If that be so, comma, at the risk of the appellant,
Please.
comma, notice to respondent number 6 is dispensed with.
Please.
Application disposed of.
Please.
Next.
25.
Appellant, please. Matter pertains to elections to a cooperative society. There is a delay of 62 days in filing of this writ appeal. I have assigned the reason. I did not file writ petition. Other advocate has filed writ petition. I have collected the writ petition papers and from Advocate General Office, and I have filed copy applications for certified copy. That was filed on 8/4/2024. Office has taken 10 days time to supply the order copy and other reasons. 62 days delay. And office has raised an objection. The writ petitioners who have not come forward to file writ appeal, they have to be impleaded. I have filed impleading application.
Which party, who have not come forward?
The page number 6 of impleading application, I have listed some 12 persons.
Who are those 12 persons?
R6 to R17, na?
My lord, first of all, whether this writ appeal will survive,
Mhm.
because when there is an alternate remedy as held by the learned single judge, whether this writ appeal can be entertained at all.
See, now what the learned single judge has held,
Please,
one, their votes would not be counted,
yes,
and they're contesting the election also,
please,
has also gone.
right.
But the only thing is the observation now, what will they challenge in the election petition? Can they
Well,
challenge the election petition?
They
You are
can
not
file a
taken-
dispute, they can file a dispute as held under section 72 C, my lord.
Only to the extent of voting rights.
Voting rights, and if there is the electoral list, there is any ineligibility, that also can be looked into by virtue of the dispute.
As a voter,
Yes, as a,
not as a contestant. Because
My
the
lord,
dual benefit which was given. Then why don't you file an appeal?
because when we look into section 70, read with section, the rules, that is rule 13.
Could be an appeal. No, just show us 17. What is that provision 70 deals with? 70 says?
70 deals with settlement of dispute, and that has to be read with chapter 4 of
So
the
tell us
rules.
one thing, what will survive in this appeal?
Please. Honorable London single judge permitted us to cast our votes.
Yes.
Then while disposing the writ petition, my writ petition is rejected, permitted to raise a dispute under section 70.
Correct.
Within 8 days.
Correct.
This honorable court, in a reported decision, in the case of S. Basuraju, they'll pass. Madam.
There is another matter today in the list, I suppose.
Yes, my lord.
Which is
Similar matters.
That is at serial number 37, my lord.
now the 37 judgment.
Yes,
When they showed
that
37.
is with regard to preparation of voter list, does not come within the ambit and scope of dispute, is what they allege. But my reading of section 70 and the rules would be, when it pertains to anything related to constitution, management, and the function of the society, my lord, if you look into the rules for a moment, this would also, whether it is electoral roll, whether it is with regard to election or any issue pertaining to the society, would be covered under the dispute, under section 70. If we look into the rules for a
But
moment.
he is not raising a dispute on that count. He is
Please.
saying what the learner single judge, when he has allowed us to vote.
Vote, right,
And to participate,
yes.
would not have dismissed it, saying that now you go and raise this election petition.
If at all you have any grievance, go and raise an election.
But tell us one thing, then why were they permitted to vote? Then he should have decided the list, saying that we have permitted them to vote. Then what will be decided in section 70?
Questioning
Once
the-
they are permitted, will that not vote be counted?
Whatever, my lord, if we look into the provisions of section 70,
Were their votes been counted?
my lord, they were kept in a sealed cover.
That's all.
And yes,
Were they counted?
Not counted, not counted,
Our count agilva.
They counted or not?
not counted.
See, that's the point.
Kept as in separate ballot box,
Said,
not counted.
then
Our
either they should
grievance,
not have
let
permitted
them
him.
go, let them count and declare the election.
See, should have been once that, notification has come for the election, they could not have been. Very well, they permitted, learner single judge permitted, so single judge are permitted to even contest.
please.
Did anyone of you contested?
No, no,
No one contested.
no.
So issue is only voting.
yes, yes.
Once voted, then it should have been taken into its logical end. Very well, you count it, whatever they have voted, and declare it.
That is left for the returning officer to determine, my lord.
Where does it say? If person entitled to raise dispute, the petitioner who have contested the election, they say contested the election pursuant to the, cannot be treated as a candidates in the fray. See, this is one.
Returning officer shall announce the results of the election to the board of held on so and so by excluding the vote cast by the petitioner. The petitioner who have contested the election.
See, it should not have been allowed.
Please.
Once you have allowed, you should take it. Now, what will happen? Eight, small Roman 8 of the direction of the learner single judge. He says, now whatever votes have been casted, you will prepare a list. You will show it to the authority where they will raise a dispute. I think you will work it out before the authority.
Please, my lord, because the authority will be the right authority to look into all these aspects with
One,
yes.
their candidature or voting right need to have been decided.
Yes,
Okay? If that, and that interim order permits,
please.
the final order doesn't permit. What is the use? They have voted, it cannot be voted. Very well, let's not go into all this. Now he has said so, you will prepare a separate list
Mm.
where whosoever has voted for whom, that will be determined by the authority under 70. You go under 70, raise a dispute. His grievance is that you permitted me to vote, but you're not declaring my vote, counting my vote. That's his grievance.
But that window is left open by the learned single judge for him.
Pardon? Oh,
The-
See, that
Win-
has been right. His grievance is once you are permitted, why it should not be? And then declare it and let everything be subject to dispute to be raised by any of the parties. Those who have not even elected, they will also raise. Then they will raise their voting right. But there should be something conclusive. But I think you will raise an issue before the dispute, before the authority concerned.
No, but in similar, in similar circumstances, the Islamic Court, in a reported decision, 2022, KCCR SN 131, direction of writ court to conduct repolling just and proper. That is the view taken by the Islamic Court, division bench of the Islamic Court. I've given citation.
No, there is no repolling. There is no repolling here. He says you will raise the election dispute.
The written order shall count the votes cast in the election council to the board council and shall announce the results.
See, Roman 8.
Not Roman 8 is not here.
This is where.
This is page number 66. 8.
What is 68?
This is 31 to 60.
Which number?
There was an interim direction to count our votes also.
This is this one. This is different case. How is 37 related to this same society?
No, my lord, that's a different society.
That's a different society.
Yes, yes, yes. This is the milk producers cooperation. That is a bank.
That's different, no?
Yes, yes, yes.
Now you will raise that issue there.
Interim direction was petitioners are permitted to cast.
You are right.
votes
We are
in the
with you.
election.
You are right.
Wait.
That stage has crossed.
And
Their votes have not been declared.
there was a direction, but they did not declare.
Did not.
After counting, the votes casted by the petitioner shall be kept in separate.
What is the
sealed
term of
ballot
the-
box.
what is the
After
term?
counting, after counting. Now they have counted, they kept in sealed box.
Where
Let
does
them
it say
declare.
after counting?
Yes, that's what is the interim direction. On 23/1/2024, passed in the writ petition by the learned single judge. Petitioners are permitted to cast votes in the election to the board of fourth respondent society to be held on 28/1/2024. The votes cast by the petitioner shall be kept in separate sealed ballot box after counting. Now they have counted. Let them consider and dispose the matter.
See, that's the reason he says you will cast, you will see in whose favor these votes have been cast. Prepare a list, produce before the authority. So raise a dispute, go there, raise a dispute, they will produce the list before the authority.
Only in respect of whether they are eligible or ineligible.
That's the issue will be decided.
Yes.
If you are eligible, your votes have been counted,
Yes.
the candidatures, the elected candidates would be announced by the authority.
The difficulty is election should, dispute should be raised within 30 days from the date of declaration of election. That was over. That
No.
was over on 28/1/2024,
But
1
you
year
had-
back.
You had,
Therefore, my response submission to lordship is,
May take shelter under this writ petition.
instead of dragging me to go and raise dispute, let there be a direction to the returning officer to count votes.
Now that dispute need to be decided. We will say so, you had filed this appeal, no, here.
Yes.
This is 10/4/24. When did you file this appeal here? You filed it on 8/5/24.
Yes.
Within 1 month, you have filed it.
Yes.
So you go there, he will decide it. What is the tenure of the office of the?
5 years.
Oh, 5 years. Oh, you have time, then go there. Better. Okay?
Then an
The-
observation may be made. Within 1 month, I will raise dispute.
Very
If the dispute is raised, the authority should not raise delay aspect.
That's right. We will say so. That's right, ma'am.
Please.
Because they have approached this court. So during that pending, he will get the benefit of this. They say that this appeal lays a challenge to the order dated. Order dated 10/4/24. 10/4/24. 6 February 24. 6 February 24 in writ petition number 2163 of 24. But why did you delay this case so long? And just show us the original, man.
62.
See.
I did not file writ petition. Other advocate has filed writ petition. He did not return the papers. I have collected writ petition papers and annexes from the Advocate General Office, and I have filed application for certified copy. And I have taken sometime 20 days to translate the Kannada version papers.
See, you applied for a certified copy on 8/4. Almost after 2 months. From the date of the impugned order. And what is the limitation for this?
60
In
days.
raising a dispute?
60 days.
60.
No, to raise a dispute, limitation is 30 days. Within 30 days, we have to file raise dispute.
So you were barred by time in any case
Please.
when you file this writ petition, writ appeal. Does it give any time, the learner single judge?
No,
So. Is there any power to condone?
yes, they can condone.
They have.
Okay.
Where is the power? There should be power to condone. Period of limitation, provided dispute related disciplinary contained. We are concerned with section 70. Which provision, ma'am?
70A, my lord.
70,
A,
capital A.
yes, period of limitation. Uh, 78(2) is the discretionary power vested with the registrar.
No, how much is the limitation here? Limitation appears to, what does it say? No
It
dispute?
says 6
Okay.
years, but provided that a dispute relating to election of a member, president so-and-so, or any other office bearer shall be referred to the registrar within 30 days from the date of declaration of the result. Notwithstanding anything contained in subsection 1, the registrar may entertain a dispute referred after the period specified in subsection 1 if he is satisfied that the person making the reference had sufficient cause for not making the reference within time.
Okay, we will say so. We'll condone it. No condone with that, he will apply for condonation.
Please, I think that.
You'll apply for condonation.
Apply.
Okay. The challenge, this is in repetition, which was disposed of by the learned single judge by stating in paragraph 10 as under. It is from the above, it is clear that the learned single judge has relegated the has stated if any person is entitled to raise a dispute under section 72C. The said dispute shall be decided without being influenced by the dismissal of the writ petition. In paragraph 6 also, the learned single judge has stated that if any dispute relating to eligibility and ineligibility of the petitioners to contest and vote in the election is raised, and its effect on the election shall also be considered. The learned counsel for the appellants states that the appellants have filed the present appeal. We find that the appeal, the impugned order is dated 6 February 24, whereas the present appeal has been filed on on 8/5/24. We have been informed now, as per section 70, the limitation period is 30 days. 70A, capital 70A is 70 days. It also the section 70A section 2 also stipulates the registrar may entertain a dispute after this period specified in subsection 1. If he is satisfied that the person making the reference has sufficient cause for not making the reference within the period specified in subsection 1. Full stop. In view of the above and noting the submission made by the counsel for the appellant that the appellants shall raise a dispute under section 70A, we dispose of the appeal by stating that if any issue of limitation arises before the registrar, the registrar shall decide the same in accordance with law, and also the fact that after the filing of the appeal before this court on 8/5/24, till date, the appellants were pursuing the present appeal in this court. Where I have said now that he intends to file an appeal, the appellants. No, what does he say? They want to file an appeal. You will go approach within 1 month?
Within 1 month.
Within 1 month. Where I have said no, within 1 month. Say within 1 month. Stop. Noting the said submission, the appeal is disposed of. It may be made clear that we have not varied the order of the learned single judge. Varied the directions of the learned single judge in paragraph 10 of the impugned order.
My lord, just one submission. I think while dictating, my lord, your lordship mentioned dispute of the limitation is 30 days. The dispute with regard to election is 30 days, and section 70, under section 70. is the dispute that he has to raise. So
Pardon?
70A is the limitation, my lord.
For 30 days.
Yes, 30 days with regard to election dispute only.
Very
So
right.
that needs to be specified. And then
No,
dispute.
but tell us one thing, will
Yes.
that 30 days come into play here? In this case? Will it be an election dispute?
I'm thinking it is an election dispute, taking into consideration the
You will
reading of
clarify
the,
30 days for an election dispute.
please. And dispute to be raised under section 70, because I think it was dictated as 70A.
No, let's be very clear.
Yes.
One, there is another confusion there. Now, it would be 70 or 70A.
70A is the limitation. 70 speaks about the various disputes that need to be raised by an individual who's aggrieved. And it also takes into consideration, if we see 72C, my lord,
But the learner single judge says, 72C.
2C. Read with your rules.
Now, if you see 72C, any dispute arising in connection with the appeal.
Yes, yes,
Election of president, vice president.
This is the enabling provision
yes,
for raising an election dispute,
yes,
22C.
yes.
And
72C
70A
is the limitation,
is the limitation.
precisely. Yes,
And this would be 30 days.
please, with regard to election.
Yes, write it 72C and 70A, we'll do it. So, but in any case, this is an election dispute, even the learner single judge proceeds on that premise, this is
Please.
an election dispute.
Yes. Much.
So we are only saying that he will, insofar as that power under 70A for condoning the delay,
Please,
though it was filed, impugned order was 6th of February, they filed it in May.
right,
It was not within 1 month,
yes.
so that he will consider it.
Yes, yes.
Except the fact that we have expressed ourselves between the filing of the appeal until today,
yes,
that need to be excluded.
yes,
It
yes,
is only the earlier period which will look into it.
yes, yes. If that also may be clarified,
We have said
because,
that.
yes.
We have said,
Yeah. Much obliged.
thank you. This board.
I request Lord to direct the registrar to dispose the dispute within 2 or 3
Sir.
months.
We have said. I know.
If the dispute is raised within 1 month.
If we make it clear, if the, appeal. We make it clear if the dispute is raised and entertained, the same shall be decided within 6 months from the date of the presentation of the petition.
Much.
Because here there is a question of entertainment would come.
Yes,
Suppose he rejects it on the ground of limitation,
right, right.
then they are out.
Yes, yes, yes. Yes, my lord.
Okay,
Much
thank you.
obliged.
Rest of the IAs are infructuous.
Right.
Okay. Next,
26. Till number 26, Shri Siddharth Suma.
Appearing for the appellant, my lords, this appeal has been filed to set aside the order dated 4/1/2020, which is passed by the Honorable Commercial Court, my lords, allowing the IA number 4, which was filed by the respondents for return of claim. Your lordship, there's just one submission. The senior arguing counsel is unavailable today due to personal inconvenience of the matter might adjourn.
what is the position of the suit?
Lord, the suit is still pending. In fact, they have not represented after its return, but the suit filed by me is still pending. There is an order passed by this honorable court in an MFA for the parties to maintain status quo. That is a regular suit. That's not a commercial suit. If your lordship may recall, last time your lordship heard it for some time, the only question that was posed by your lordship was, this was a future agreement that they had created. In the year of 2016, they said it will come into effect from 1/4/2020 for commercial purpose. And your lordship rightly asked whether the property was already put to commercial use because the suit was filed much prior to the date of coming into the force. So that was the question. My learned friend had taken time saying that whether that fit out period can be construed as a commercial period or not. That was the only point.
What do you want, ma'am?
My lords, I seek an adjournment, my lords, because the counsel is actually is unavailable today due to some personal inconvenience.
Just say the request for adjournment is made on behalf of the counsel for the appellant. Adjourn to.
To. Till number 27.
Please.
27.
Milord, I appear for issue number 1 in this matter. Milord, in this second matter, Milord, 27.1.
Who appears in one? First one.
I am member of
Milord, in this matter, Milord, on last date of hearing, 12th November 2024, Milord, after arguing for some time, Milord, this honorable bench expressed that once, since limitation, that the limitation is applicable to application under section 3G5 is pending before Honorable Supreme Court. Like it is.
We have adjourned also some more matters. What is the position still pending?
Still pending, Milord. And note next date is also given, Milord, as well.
How is this 27.1 connected with 27?
Milord, I have no idea.
We have no idea.
Because I don't appear in 27, so I'm not sure.
Is 27 is also the same thing.
Arbitration petition filed by the NHA is allowed. So
No, their limitation.
Wait.
is less. Both matters that limitation issues there.
Yes, just say this. Counsel for the party states that the appeals be adjourned as the issue which falls for consideration in these appeals is pending consideration before the Supreme Court. Adjournment. No.
25. 4.
Obliged.
8. Number 28. Change mark.
This pass over.
29. Any history?
For the appellant, my lord,
Yes,
matter is part heard. This is a arbitration suit that was filed and that was dismissed, my lord, where
We'll
My
just
lord.
pass over, man. Just pass over.
30. Till number 30.
For the appellant.
Yes.
Item number 30. I'm seeking a passover, a short passover, Milord.
31.
Connected, madam.
Same.
Is it connected?
30 and 31 are connected.
Yes, sir. Pass over.
32.
Okay.
No, for the respondent. Lord, in this matter, my lord, appellant was heard 3 days back.
My lords, the other day, my colleague had made a submission, my lords, with respect to the amount to be deposited before the trial court, my lords, for remanding back the matter. My lords, my instructions from the client are, my lords, that the amount may kindly be reduced to at least, my lords, 15 lakhs. According to,
How much is the liability?
my lords,
My lord, we already have a decree in our hand, my lord. It's Order 37 summary suit, which has been duly served on them. We have a decree in our hand, an execution petition has been filed. And the summons itself in Order 37 matter says you have to deposit the 100% of the amount, then only you can appear and to enter appearance also.
Today I have a decree in my hand, so he can't bargain on the deposit amount, my lord.
My lords, my instructions are, my lord. The reasons, whatever that may be, lords.
But what is your defense even on merits?
My lords, merits also, my lords, we have got good defense, and with the calculations that we have over here, my
See,
lord,
there is
there's
a
a dispute, my lord.
There is a decree that must satisfy.
Absolutely, my lords.
No, you will deposit.
My lords, deposit itself, my lords, I'm just asking the kind indulgence before this court that the deposit may kindly be reduced, my lords, not to
Very
the,
well, you deposit the principal amount minus
well.
the interest.
my lords, very well, my lords. Principal amount, my lords.
It's
Then
24 lakhs, my lord. The principal amount is
25,87,660.
Yes.
But if my lords may kindly enlighten us, interest part, my lords, may kindly be.
That's why we are telling you,
My lords,
you deposit 25,87,660.
my lords, if a humble submission, my lords,
Very well. See, it's not a case you have not received the summons.
Yes.
my lords,
You don't file it, you don't take it
That's-
forward.
my lords, being a very diligent company, my lords,
That's the reason we are
But-
giving you an
yes, ma'am.
opportunity
my
to
lords,
contest that.
grateful, my lords, I'm deeply obliged,
So you will deposit it,
my lords,
we will revive the suit,
my lords,
uh,
my lords,
and will it proceed as a normal suit?
my lords,
Lord,
yes, my
order-
lord,
no,
it has to
lord.
proceed as a normal
Summary suit, my lord, because I have two balance confirmation from them in their case, my lord. It can be a summary suit. They need to file an IA to seek leave to defend, my lords.
Leave to defend, that is, with all,
When will you file leave to defend?
well, immediately, my lords,
How much time?
my lords,
1 week.
1 week, 10 days, my lords, 1 week to 10 days,
10 days you will file leave to defend.
Definitely,
Then thereafter he will proceed in accordance with law.
Yes.
But
Definitely.
before that, on the first day,
my lords.
along with the leave to defend, you will deposit this amount.
My lords, my lords, deposit of the amount, my lords, yes, we do agree, my lords. My only humble submission is that, my lords, if my lords may consider this, my lords, there is a dispute and definitely we owe some money back to them. There's no doubt, but according to us, it's around 7 to 8 lakhs.
Again,
So what do you want? Only 7 lakhs you will deposit?
No, my lords, my lords,
Then-
at least, my lords, if I may suggest, put it across, if my lords may.
Very well, I think we will hear it.
My lords,
Yes,
no, my
we'll
lords,
hear-
we are ready, my lords,
We will hear it.
my lords,
Yes, ma'am.
my lords,
Decide it.
my lord, we are ready, my lords, we are ready. But the only indulgence,
But like
from my end, my lords, from my end, my indulgence.
See, if you were to be in his position, you have a decree in your favor.
No, I do agree. I
At
bow
his
down.
fault, because of his fault, despite summons, you don't file leave to defend. What will the court do?
My lords,
See, we have to balance the equities. What we are doing, you will deposit, the money would be in the court. You will
Grateful.
contest it. If you succeed to the extent possible, you will get back rest of the money.
very well.
That's all.
I bow down, I bow down.
Just say this, the challenge in this appeal is to an judgment decree dated 15th April 2024, passed by the Additional City Civil Sessions Judge, so-and-so Bangalore, deciding commercial OS number 1537 of 2023. The said suit was a summary suit filed under Order 37 CPC, which was decreed by the learned court by stating as under, just reproduce that order, page 19. Suffice to state, the appellant herein, despite service, had not filed the leave to defend. The resulting in the decree in favor of the respondent herein. First, the counsel for the appellants would submit that inadvertently the leave to defend could not be filed. Otherwise, the appellants had a good case on merits. Though he states, now we are recording your submission,
My lords,
though he states that some amount is payable
Yes.
by the appellant to the respondent, but not to the tune of 25,87660, as has been granted by the
very,
court below. Full stop. He states that if one opportunity be given to the appellant to file a leave to defend within 1 week, so that the matter can be, the petition can be argued to that extent. Full stop. You will file any affidavit?
No, my lords, I have all the pleadings, it's filed, my lord.
Full stop. This submission is agreeable to the learner counsel for the respondent, provided the appellant deposit the amount of 25,87660 before the court concerned, before the trial court, on the date when the leave to defend is filed within 1 week from today.
grateful.
Full stop. The same is agreeable, full stop, noting the submissions, comma, the judgment decree dated so-and-so is set aside, directing the, granting liberty to the appellant to file leave to defend within 1 week from today. Okay, and on the date when the leave to defend is filed before the court concerned, an amount of 25,87660 shall be deposited by way of a demand draft. Full stop. And thereafter, on such a leave to defend being filed, the trial court shall proceed in accordance with law. Full stop. And decide the list between the parties. Okay.
My lords, if I may submit, my lord, in the meanwhile, some cost may be imposed, my lord, because trial court proceedings and execution proceedings are now here, my
Very well.
lord.
Some cost must come to him.
My lord, sir, cost.
Because 3 legal proceedings, my lord, my client is also incurring expenses for the same.
Full stop. The appeal is disposed of on payment of cost of rupees.
One lakh, my lord.
That's 1 lakh is exorbitant.
10,000.
20,000.
See, you say 1 lakh, but you laugh. You know. Payment of cost of rupees 10,000 to the respondent to be paid to the respondent on the date of filing of the leave to defend. Okay,
My lord, sir.
thank you.
Obliged.
My lord, sir, them directed to serve the copies of the entire set of copies, my
No,
lord.
it has been served on them. They are only saying, so, I mean, I can give it, I'll give another set. Yes, yes, yes.
See, now the time would run only after you serve.
Yes, my lord.
Just give him a copy today only.
Yes, my lord.
You take, just say that,
My lord.
though the learner counsel for the appellant would submit, you must be having the suit copy.
Only the plain copy is there with us.
No, no, plain with documents only has been served. We can't give only the plain, my lord. Plain with documents
Whatever
only.
it is.
See,
They'll
we will be recording only, see, we will be recording that he will be giving a second set to you.
Definitely.
The learner counsel for the appellant states that the counsel for the respondent be directed to furnish a fresh set of the appeal and the documents.
Press it, the plain with
Plain,
documents.
Paint and the documents. So let the same be supplied during the course of the day.
Yes.
Okay, appeal, that's all disposed of.
My lord,
Next.
there is a court fees which has been paid here, my lords, for filing the appeal, my lords. That may, before the High Court, my lords. I am permitted to withdraw that.
Yes, we will not.
Yes, he's got the benefit of the appeal. my
Yes,
lord.
we will not allow.
Yes.
I'll just leave it to my courts. I made my submission, my lords. I'll just board on to my lords.
That's all. This we will not.
Great, great.
Thank you.
Obliged, obliged.
33.
My lord, I appear for the respondent in this matter, my lord. My lord, on the last occasion also, your lordships have noted the absence of the counsel for the appellant, my lords. This is the third such situation.
Just 1 minute, ma'am.
Very well.
Just say none for the appellants. We find there was no appearance for the appellants even on the last date of hearing. The appeal is dismissed in default and for non-prosecution.
I'm grateful, my lord.
34. Ashwini.
Appellant in this case, my lord. This is an appeal filed against the order of the learned single judge dated 21st November 23, my lord. This is a service matter, my lord, wherein I have challenged the recruitment of all the private respondents as being illegal, my lord. However, although I have been promoted to the post that I have asked for, the judgment, the impugned judgment still notes that the respondents, the private respondents must be placed above me, my lord. I have highlighted in my writ petitions as well as a writ appeal hearing all the illegalities in the appointments of the respondents, my lord. I would like to place on record some of the points that I have put down to show that the appointments itself were illegal, my lord, let alone irregular, based on which they cannot be ratified at all, based on which they couldn't have been promoted above me at all, my lord.
Who?
The private respondents.
In which organization?
In KPCL, my lord. KPCL is the organization. My lord, in fact, the first point that I'd like to place on record,
But you
notice
got
has to,
absorbed in KREDL,
KREDL, I was placed on deputation in KREDL, my lord.
but you got absorbed thereafter.
Yes, I got absorbed, my lord.
What remains in KPCL?
Yes, my lord. In fact, both the orders are before your lordships, my lord. The first point that I'd like to make in respect of my submissions, my lord, all the appointment orders issued to the private
Do
respondents.
not press this KPCL. You may press possibly the KREDL.
The CREDL, my lord.
Now
Yes.
come to KREDL.
Yes, my lord. In fact, all the appointment orders issued to the respondents, my lord, were issued on a Sunday in great haste and in complete disregard of every
Promotion to
other
which post?
promotion to the post of assistant
Technical
techni-
officer.
Yes,
Very good.
technical officer. That's
Now-
number one, my lord.
One, what is the eligibility for technical officer? Were you given the promotion to technical officer?
I was not given. I was recently given, my lord. In
When?
fact, on
When?
I was given on 8/2/2024.
So let's go by this. So you are not pressing the appeal qua KPCL, okay? Now you are only saying KREDL, okay? Now, when were you absorbed, from which date you were absorbed in KREDL?
I will just place that on record 1 second, madam. I was absorbed with effect from 1/4/2012, my lord.
As assistant technical officer? That's right?
Yes.
Now, what is the promotion post is technical officer?
My lord?
Promotion post is technical officer.
Yes, my lord.
What is the eligibility?
Eligibility is as per the notification, my lord, and I am eligible, my lord.
What is the
As-
eligibility?
I will just place that on record, ma'am. But from junior engineer to assistant engineer electrical, I've already been promoted, my lord. From assistant engineer, I have been promoted again to
Ma'am,
the next post, my lord.
this may not be relevant. This is in KPCL.
Yes,
We
my
are
lord.
concerned in KREDL.
Yes, my lord.
So your date of absorption is 1/4/2012.
Yes,
So
my
that would be the date which will determine the eligibility in KREDL.
That's right, my
How
lord.
much is the eligibility?
The eligibility is that I should have had an engineering degree, my lord. I should have had an engineering degree and also delivered 5 years of service on the project site, my lord.
This would not be relevant. This would be relevant only for KPCL.
No, I'm also pressing this against KPCL, my lord, because I have been deputed from KPCL itself, my lord, to CREDL. In fact, both the judgments address
What
both
we are putting it to
respondents.
you,
Yes,
once you got absorbed in KREDL,
yes,
what remains in KPCL for you? Let's be clear. So KPCL, you have been absorbed as assistant technical officer.
yes,
And once you have been absorbed in assistant technical officer, you would not get anything based on KPCL except your, not even seniority. Your date of appointment in absorption in KPCL is on 1/4/2012. Any benefits which would be accruing to you in KREDL would be from that date. So we are concerned with promotion to technical officer in KREDL. Your date is 1/4/2012.
yes,
What
madam.
is the eligibility for promotion to technical officer?
I will have to pull that order out, my lord. It is in the recruitment
No,
notification.
let's see
in
the
fact.
learner single judge order.
Yes, my lord.
We'll get it. Now come to
Yes, ma'am.
paragraph 5.
Yes, my lord.
This would be page 11, internal page 11 of the impugned order.
Para 5, my lord.
Now read that paragraph.
As already stated above, the petitioner was absorbed into the services of CREDL with effect from 1/4/2012, and 3 years after her services were absorbed, on 5/8/2015, she made a request for retrospective promotion with her erstwhile employer.
That's
is-
KPCL.
It is obvious that the petitioner could not have claimed for a promotion and that too retrospectively after she had left the services of the parent
So
department.
that's justification is just appropriate.
My lord, I have one submission there also, my lord.
Tell us.
In fact, in fact, this judgment puts the onus of claiming that there is illegality of service on me as the appellant, my lord. In fact, throughout the judgment, there are several paragraphs I have noted in my writ appeal, which show that the onus was on me. Why have I come late to show that the respondents were not qualified? Why have I come late to show that I am more eligible than itself? No, that the certain persons who were promoted were not even eligible for those posts, my lord.
Once you have been absorbed in KRE, 1 minute. And your appointment in KREDL is an assistant technical officer. Okay. Let's assume hypothetically, even appointment in KREDL will only start from assistant technical officer. You got absorbed as an assistant technical officer. Even if you get a promotion on a higher post, you would not, your designation in new employer would not change.
My lord, it would still affect me because the promotion, the date of promotion of the respondents, my lord, to the same post as I am claiming is 20, 1 second, my lord.
Now read further. Let's see that come to paragraph 6, page 11.
It has to be stated here that the promotion in her erstwhile employment.
That's what we are saying. Okay. Now come down.
It is obvious that the petitioner making a claim being absorbed into a higher cadre in CREDL. In my view, having regard to the fact that the petitioner staked a claim for promotion nearly 4 years after her batchmates were promoted, my lord, again, the entire case seems to be on the delay, my lord. That is my claim, my lord.
Let's overlook delay.
Yes, my lord. If the delay was overlooked, my lord, I would have been promoted much before the certain private respondents in this case, my lord. And hence, my job opportunities would have been very different. The place on which
Let's consider that also. KPCL. Now, what was your designation there in KPCL?
I was promoted to assistant executive engineer, my lord.
When?
My list of dates has all the information, my lord. I was promoted to assistant engineer electrical on 4/5/2004, my lord.
Assistant engineer or assistant executive engineer?
Assistant engineer electrical on 4/5/2004, my lord.
Okay. Then
I was deputed to CREDL on 25/2009, my lord. So I was assistant engineer electrical at the time when I was deputed to CREDL as ATO.
Now you continued in CREDL thereafter till you absorbed. Now, did any of your juniors got promotion in KPCL? And if yes, from which date?
They got promoted on 24/4/2023, my lord. 24/4/2023. The same post. Yes, my lord. That
from
is
which
what,
date? From which date? See, it's simple.
Yes, my lord.
If they got it from 23, but you were absorbed in 2012, much after you were absorbed, they got promotion. So you can't claim any promotion qua those juniors because they got much after you got absorbed. You have severed all your relations with your previous employer.
My lord, the point is completely taken, my lord. In fact, I'm more on the second writ petition, my lord, where I'm
That's what we are telling you. So in CREDL.
Yes.
Now come to CREDL, come to para 10.
Yes, my lord.
Read paragraph 10 onwards.
The petitioner has filed this writ petition seeking a mandamus to be issued to respondent number 2 to grant her promotion to the post of technical officer with effect from 3/6/2014 and consequently to also consider her for further promotion as an AGM from the date the petitioner was eligible to be promoted to the post of the technical officer as provided under the CREDL Cadre Recruitment and Conditions of Service Rules 2001, my lord. The petitioner is also seeking, this is my prayer in my writ petition 10801, my lord.
Read it.
The petitioner is also seeking quashing of the seniority list dated 11/2/2020 and for a direction to the credit to prepare a fresh seniority list. A further prayer is sought to declare the appointment of respondents 4 to 8 as violative of credit's CNR rules. The petitioner is also challenging the order of suspension dated 12/2/21 passed against her pending inquiry into certain misconduct that was alleged to have committed by her. And she has also challenged the order dated 17/2/21 by which the order of suspension has been revoked. In addition, the petitioner has challenged the notification dated 6/4/21 by which the credit CNR rules have been amended and the action taken by the board for absorbing respondents 4, 5, and 8 was ratified.
Okay, now
Yes,
just,
madam.
all these are not relevant. Once you are not pressing your KPCL, this thing, come to page 16, internal page 16, paragraph G onwards, you start reading.
The government, by an order dated 28/1/2012, accorded its approval for the absorption of the petitioner into credit, and accordingly credit proceeded to issue the office order dated 21/4/12, 8/5/12, absorbing the petitioner into services of the credit. The operative portion of the order under which the petitioner was absorbed reads as under. As
Forget
could be
that,
seen-
come to 14.
Yes, as could be seen from the order of absorption, the seniority of the petitioner was assigned the last ranking in the cadre of the ATO, since the absorption was at the request of the petitioner.
That's right, now
And-
stop here. What have they said? Your seniority would be at the
Okay,
assistant
okay.
technical officer. That's the post which you got absorbed.
Yes, my lord. I also admit to that, my lord, because at that point in time, I was not aware of the illegalities in the recruitment of the respondents at all. Hence, I did not challenge this at all, my lord.
So you did not now come further. Since absorption was at the request of the petitioner, she thereby lost the seniority that she enjoyed in the parent department.
That is also not true, my lord. I've also challenged that in my writ appeal, where I've said that they are the ones who called me back because I did not give any request to be back to the parent company.
But in any case, now
In-
that's a
In-
history now, ma'am. Once you now been absorbed.
I agree, my lord. However,
Once absorbed, you will lose everything. Your fresh appointment or the service would start from KREDL. You got absorbed on 1/4/2012 as an assistant technical officer.
yes, my lord.
Now you have to only show this. So your seniority would be from 1/4/2012 in KREDL as assistant technical officer. Now, what is the eligibility for technical officer?
My lord, I'll need some time to bring the notification, my lord. However, meanwhile,
Just read 14, 15, 16, ma'am. Let's see.
yes, my lord, I have also challenged these in my writ appeal itself because 14 says that I have thereby lost the seniority that I enjoyed in my parent department KPCL. The loss of seniority was not disputed by the petitioner, and then she continued to work in the junior most post. This is exactly my point, my lord. I was not in my, I was in fact on maternity leave. I have a special child. I had several reasons to challenge this at all. Later on, challenge the illegalities of the appointment of the private respondents, my lord. In
To
fact,
which post?
they're all in the same cadre as me, my lord.
It's in earlier employment.
No, in this employment itself, my lord, they have
Uh-huh.
also been promoted to technical officer, my lord. In fact, I have challenged, in fact, the reason for delay itself, like throughout the judgment, I've been asked why I did not come forward, why I accepted this line in my absorption order, which says I'll be placed below.
Which line?
In whatever I just read out just now, my lord, since the absorption was at the request of the petitioner, she thereby lost the seniority that she enjoyed in
But
her
tell us
parent
one
department.
thing.
The loss of seniority was not disputed by the petitioner, and she continued to work as a junior most ATO at Credel, my lord. I continued to work because I did not know that there were illegalities. Later on, I filed an RTI application. I came to know that one, they're not qualified at all to the posts. Number two,
Which juniors, which illegalities, in which post?
I will just point out my writ appeal, the relevant paragraphs of my writ appeal, my lord, where I've highlighted specifically the problems in the
Recruitment where?
recruitment of the private respondents in Credel, my lord.
In Credel?
Yes.
No,
So-
no recruitment to the post of assistant technical officer.
Yes, my lord.
When you were also appointed.
Yes, my lord. In fact, from their recruitment itself is illegal, my lord. They were made on Sunday in great haste, number one. Number two, some of these, they have not even been qualified. I've produced the certificates of their non-qualification. I mean, in fact, certificates which shows that they're not even qualified to the post.
Where
In the
is
writ
your
petition.
prayer in the writ petition?
In the there are two writ petitions,
In
my lord.
credal writ petition.
Page 269 onwards, my lord. The synopsis and list of dates start.
260.
I will just say the specific page number, my lord. The prayer is in page number 318, my lord, where I've said issue a writ of mandamus, direct the respondent number 2 credel to grant promotion to the petitioner as technical officer in respondent number 2 credel with effect from 3/6/2014 and consequently be considered for promotion as the AGM in respondent number 2 credel.
So you did not challenge their appointments.
I have also challenged that, my lord.
Where is the prayer?
3, my lord, sub prayer 3, declare the appointment of the respondents number 4 to 8 as violative of the credel service rules as being illegal, irregular, and not in accordance with the settled law. So specifically challenge the respondents' recruitment, my lord. Even though the learned single judge in his impugned judgment has given me promotion, I am not challenging that at all, my lord. In fact, I deserve that promotion, my lord. Which is why my prayer is to set aside the judgment to the extent that I'm still placed above these private respondents, even though their non-qualification is very clear. And I've also pressed this in my writ petition. However, I've not been heard. In fact, none of my points have been
When were
considered.
these people, you were appointed in credel?
My lord,
When were you appointed in credel?
I was absorbed into service
1/4/2000.
yes.
No, when did you came on deputation?
I
What's the
came to
time when
deputation
appointment?
25/2009, my lord.
2009.
Yes.
Where is it? 18. Now come to page 20 of that impugned order.
Yes, ma'am.
Now, are you challenging the appointments of these people?
Yes, my lord. The respondents. I will just read out the list.
Ravindra, Dinesh, Ravindra, Radha, Pallavi.
Ravindra, Dinesh, SR Ravindra, Radha Kondur, and Pallavi HC. Yes.
You are challenging these appointments?
Yes.
Now, they were appointed in, when were they appointed in credel?
My lord, each of them has a separate date, my lord. That is listed here. Ravindra H. Kori was on 31st October 2001.
2004, 5, 6, and 6.
Yes, that is on, the date on which
Now,
they were absorbed.
when
my
they
lord.
were appointed, you were not in credel. You came in 2009 as a deputationist. As a deputationist,
Yes.
what right you have to challenge their appointments?
My lord, I was later absorbed to the post, my lord.
It's all right. But they had come in 2001 when you were not even in credel.
I agree, my lord. However, their entire recruitment itself is illegal, my lord.
Forget
That is
it,
my
ma'am. How
entire.
can you challenge it? What is your locus?
My lord, I'm an affected party by, because the promotion list, the DPC was conducted after a period
Nothing
of
doing.
20 years, my lord.
It's all right.
That DPC was conducted only
Oh,
after
no.
we challenged all this.
Oh, no. They had come in 2009, much before you had come to credel. Much before. You can't challenge their appointment saying that their appointment is now affecting my promotion to the technical officer, hence their appointment is bad. That's your submission.
My lord, the recruitment itself is illegal, my lord, on several
It was
counts.
illegal, patently illegal. Let's assume so.
Yes, my lord.
When was that done?
On various days,
2001 to
2006.
Very well.
Yes.
Let's assume. Assume you had not come to the credel. Whether you could have challenged their appointment? You
No,
could not have.
I would not have.
You could not have.
Hmm.
You had come in 2009 as a deputationist. You did not come even as a direct recruit. They had come as a direct recruits. You could not have. You had come as a deputationist. There is no comparison between a direct recruit and a deputationist. You got absorbed. In 2009, you came, 2012, you got absorbed. What locus you have to challenge their appointment?
My lord, we're all in the same cadre, my lord. We're all in the same cadre.
Right.
In fact, their placement above me affects my promotional prospects to my next cadre, my lord.
It may affect,
It
but you have
definitely
no
affects my
locus to challenge their appointment. Let's be clear.
I am an aggrieved party, my lord. I'm directly affected by their promotion, my
I
lord.
will not agree with that submission, ma'am. Let's be very clear. Not at all. Someone had come by way of an appointment. You were not in that department. And you say their appointment was wrong today and their appointment must be set aside so that you can get promotion before them. That's your plea.
My lord, the learned single judge has not taken this point at all, my lord. In fact, if this was the argument, my lord, in fact, if this was the rationale on which the judgment was based, I perhaps would not have challenged it at all, my lord. In
Obvious.
fact, why I'm challenging it is because throughout the judgment, not even one averment as to the lack of qualifications of the respondents has been gone into, my lord. In fact, the onus of challenging them has been on me. Post Uma Devi's judgment, my lord, the criteria that needs to be satisfied, that there has to be a sanction post and their appointment to sanction post can
We are
happen.
asking you your locus.
My lord, my locus is that I'm in the same cadre as them, my lord. If they are placed in some certain positions, my lord, and I'm placed below them, definitely it affects my promotional
You have
prospects.
your promotion, but their appointment was made in somewhere much before you had come.
Irrespective, my lord, we're still in the same cadre as of today, my lord.
It will not. And now we are asking you, you tell us what was your locus to challenge their appointment? You had come on deputation, they had come in direct. Let's assume for a moment they did not have the qualification. What was your locus? You had no locus, you had come on deputation. You got absorbed.
No, I was sent on deputation only by my parent company, my lord. It's not that I had requested for it
You're
just
right,
because
but
I am
that plea you can't now take it.
No, I'm not taking that plea at all, my lord. I volunteer your lordships on that point, my lord. However, it still remains that we are in the same cadre, my lord. Patent illegality in the appointments, my lord. At least notice may be issued. I may be allowed to argue the matter on merits, my lord. I will place
You have
before
to,
your
ma'am,
lordship.
you have to satisfy the appellate court also. We are now putting it to you.
My lord, specific paras of which show that they were not qualified may at least be seen, my lord.
We are with you on that. Let's assume. Can you challenge? When did you file the writ petition? In 21?
Yes, my lord. 2016
Very
was
well.
the first writ petition.
Can
my lord.
you in 2016, having come on deputation in 2009, absorbed in 2012, filing petition in 2016 for an appointments which were made in 2001 and 2004, 2005? Answer that.
That is precisely my point, my lord. The onus is on me to ensure that, to show that there's illegality in appointment. There's gross illegality, number one, my lord. Number two, even though there's a delay on my part, I have explained the delay both writ petition as well as my writ appeals, my lord. One, I was on maternity leave. And second, because I have a special child, I had to take some more days off in order to take care of my child. And once I was back is when I realized that they were given the promotion, my lord, which I was also due. And only later on, I filed an RTI to understand why those promotions were granted and on what basis they were eligible.
When were you due promotion to the technical officer? According to you, what is the eligibility? Tell us.
That I will need some time, my lord. In fact, the matter may kindly be posted even tomorrow, my lord. I will satisfy this honorable court and
We want to know what is the eligibility for technical officer. We want to know that.
I will put.
And
put
what
it
is
down,
your
my lord.
status today?
I will put that down,
You
my
are
lord.
a technical officer today?
Yes, my lord.
When were you promoted as technical officer?
I was promoted on 2024, my lord.
24.
Yes. After
After-
the judgment of this honorable court.
After the,
After the judgment, because the learned single judge had ordered that I be promoted.
where does the learner single judge say you have the eligibility for promotion? Does he say so?
But he's ordered that I may be promoted, my lord.
You very well. You get the instructions.
Yes, my
What
lord.
is the eligibility for technical officer?
I will do that, my lord.
We will look into. Just say that we have heard the counsel for the appellant. Full stop, to enable her to seek further instructions. Renote. When do you want?
Anytime next week is fine.
Very well. Just give next week.
Obliged.
My lord, copies may be served on us, my lord. I accept
just
notice
give
for R1.
A notice may be ordered, I've already served. In fact, I will serve another copy, my lord.
You are there, ma'am. We will hear you. Next.
I will serve another copy within the next date of hearing.
No, she wants whatever you are filing should be given to you, given to
Oh,
her.
yes, I will do that.
Next.
Serial number 35. 4-2, madam. 4-2, madam. Date. Serial number 35.
Happy with the appellant.
Yes.
And before my lords, challenging the order of the learned single judge dated the 18 January, my lords. The brief facts, my lords, that I am the owner of 2 acres of land, which was granted to my grandfather in 1970.
Yes.
We have been in continuous possession of the land, my lords. In 2002, the 5th respondent went to the revenue authorities and placed his claim over the land which I was owning. The revenue authorities decided in his favor, which was challenged in the Honorable Appellate Tribunal, which again upset the decision. And he had carried it as a writ petition before this Honorable Court and withdrawn that, stating that he would file a review before the Appellate Court, the Appellate Tribunal. Thereafter, the land in another petition, which was again dismissed, stating that it has been filed 25 years after the grant was made to us. Hence, he couldn't do it. So the order is.
But this is what was your claim before the?
Because now what has happened?
Before the learner single judge.
The respondents have acquired my land. They have not paid me the compensation.
That's right. But there is some claim by a third party also.
Kindly see that claim, please, my lords, that I have produced it as a.
But who would decide the claim?
My lords, it is not in respect of this land at all, my lords. That is what I was bringing to the notice of.
Sure.
Kindly see page number 297, my lords.
This is not in respect to this land.
May I just read it, my lords? My lords,
Sure.
regarding certifying, as concerned to aforesaid subject, from the Pahani records, it has found that khata of 2 acres of land in survey number 98 in Karehalli village, Tyamgundlu, Hubli, Nilamangala Taluk, Bangalore rural district, has been registered to Sri Sharif Ishaq, Muhammad Ishaq, and Muhammad Salim Abdul Arif, son of Muhammad Ishaq. This is the petitioner's parents. This is, they have their own finding. 98/2, 2 acres of land is in my name. Kindly see. The said property has been acquired for the MMLP purpose. Shri T. Govind Raju, son of late Timaya, has submitted the objection while distribution of compensation. The said survey number 97, he is undertaking unofficial cultivation in the said area. That he is cultivating the land in 97. 97, I have no claim, my lords. I have never made a claim for 97.
And he has also never made a claim for
97. This is the first time.
What do you say?
Those papers are not given to us, only.
No,
They're enclosures of the writ petition, my lords.
Was it part of the writ petition?
Yes. This was what was brought to the.
Very well.
notice.
Then we will issue notice. You must look into it. See, because the impression one gets is there was a third party claim also. Third party claim, you must
Of some other server.
just say this, where is the ground in this appeal today? Where do you say there is no claimant for this land which has been acquired, your land?
21, my lords.
Page?
Page number 12, paragraph number 21.
Just say this. The challenge in this petition is to an order dated 8 January 2024. Passed by the learned single judge in writ petition number 179 of 2024. Whereby the learned single judge has dismissed the petition filed by the appellants herein. The submission of learned counsel for the appellants is that the finding of the conclusion drawn by the learned single judge in paragraph 2 and 3 is erroneous by stating that there is no claimant.
Please.
There is no claimant in respect of the compensation to be granted, to be given to the appellants herein. Full stop. In support of his submission, he has drawn our attention to paragraph 21 of the memorandum of appeal, to also state that the conclusion drawn to the finding of the learned tribunal, learned single judge, that claim has been made by third parties is not with respect to the survey number 98. Full stop. In this full stop. But in respect of survey number 97. Issue notice, so and so accept notice to the respondent. You appear for?
I am appearing for second respondent. Will take notice for third respondent also, my lord.
2 and 3, ma'am, you appear for?
1 and 4.
1 and 4, and let notice be issued to respondent number 5.
The answering respondent.
1 minute, just 1 minute,
Award is passed.
just 1 minute. Yes, what does it say? Who owns survey number 97? Minutes? Who owns 97?
I have no idea, because 97 was not in.
What is the purport of paragraph 22 of the appeal?
The acquiring authority has also issued a paper publication wherein objections were called for. Milords, at public at large and interested persons in the said survey number proposed to be acquired. It would have been prudent on the part of the respondent number 5 to approach the authority laying his claim on the ownership of any land proposed to be acquired. Having lost the legal battle wherein his claim of ownership of land in survey number 98 V2 was dismissed, he came up with the claim of ownership of land in survey number 97 based only on figment of imagination and without producing a single document in support of his claim. In spite of such a frivolous, baseless and imaginary claim, the third.
But he doesn't own 97. He doesn't own 97. Huh? You have no claim for 97.
I have clearly mentioned, no, I have 98.
Now, what kind of a dispute was dismissed, rejected against 98?
98.
98, my lords, I produced the orders. At 226, my lords, page number 226, the Karnataka Appellate Tribunal order is there, where
he made a claim for 98.
98. In all these three petitions.
Just say that part. Issue notice to respond. Next.
Grateful.
Copies
Of the appeal.
Appeal because it's only incomplete, all the papers.
Just give them a
I'll do it
complete
now.
copy.
I'll do it now.
Likewise for the state, my lord.
He will give it to everyone.
94, serial number 36.
Just say that, don't say, let them go. My lords, I'm for the appellant in this
Hearing for
matter.
all.
I request for a passover, my lords. Which is the number, ma'am? 36, my lords.
Appearing for respondent number 22, madam.
Ma'am. Yes, ma'am. I request for a passover, my lords. Paso.
37, 37, Shri Basaraj.
My lord, short accommodation may be granted, my lord.
Yes, at the request of counsel for the
Cooperative sector.
adjourn to appellant, counsel for the.
18-3. Serial number 38.
For the appellant, kindly press for short accommodation. Senior is not well.
At the request of counsel for the appellant removed.
20th March. Serial number 39. Keshav Datta. 39.
Hearing for the appellant's minutes, short question for consideration. Since so far as the enactment of the BBNP Act is concerned, the short question is the learned single judge has quashed the demand notices, but reserving liberty, but the demand notices were with respect to the act in which was prevalent at that point in time.
Which page is this? 13, 14.
39.
Yes. Let's see. How do you answer repeal and saving clause?
It's now the act came into force only on 11/1/2000. Prior to which was the Karnataka Municipal Corporations Act. Now, because we have issued notices in terms of the old act, because for the year that we are seeking for the demand.
Acha, you are for the
Authority.
Anagar Palike?
Please, ma'am.
Will issue notice.
Delay was also there. Notice has also been issued. But if a delay of 60.
You would be relying upon repeal and saving clause.
I would be relying on repeal and saving clause. It's a very limited.
There is
question.
another connected matter, I suppose. There is another matter today.
41, my lords. Seal number 41 is.
Who appears for them?
My lords, it's a different respondent altogether. The petitioners are two different.
Just say this. Issue notice.
My lords, notice has already been issued, served as well.
Then we will take it up with 41.
Grateful. my lords.
That's the 41. You are the same, na?
I am the same, but the respondent in both the appeals.
Let's see who is the counsel who appears. Let's
It
call the.
could be had next week, but some.
Just wait, it's next
Wait.
to next matter only.
39 passers.
40, ma'am. We'll take 39 with 41, huh?
40. Serial number 40. Naik. 40.
Just pass over.
42.
41, 41.
41. Serial number 41. Vijay Kumar.
Just saying both the matter, none for the respondent. Get your note of submissions
Please, my lords.
and any judgments you want to. There would be many on this.
There would be many, my lords. I'll place reliance.
Just say that the request of counsel for the, none for the respondents, re-notify.
My lord, if it could be clubbed together, my lords. Because
Have it on the same day. Just have it on the, all the question is same.
question is the same. my lords.
Just say this, as the issue arises in appeal number 689/2024, item number 41 is identical to the issue which arises in this appeal. Both the appeals are tagged together to be heard together, are tagged together. Full stop. None for the respondents, re-notify.
10-3.
Grateful.
42. Serial number 42.
I appear for the appellant in this case. Looking for a short accommodation.
What is the difficulty?
Lords. Senior is on his legs in other court, my lords. We have a man.
We'll come back after lunch. Okay?
Lords.
Yes, he will get up. Mr. Srikanth,
Yes, my lords, I am ready, my lords. If it can be taken up at 2:30 itself, my lords.
you want to file a document, we'll give you a document.
No, my lords.
Time. It's there with you.
It's there, my lords. It can be taken up at 2:30 itself, my lords.
We'll take it up. We'll take it up.
Number 47, my lord, finally.
Yes.
Most of the papers are in Kannada language. Number 47.
Who appears for the other side?
Other side, I have informed.
I moved the matter.
Yes. What do you want?
Emergency.
You said 47, na?
47.
What do you want?
Not accommodation.
But who moved the CH?
I moved the thing. I am for the respondent 1 to 8.
At the request of counsel for the appellant. Appellant re-notify.
Some urgency. Some urgency.
See, we will give you date as per our
My
convenience.
lord, serial number
Serial number
49.
12.
Just give a date.
Date may be given.
My lord, serial number 49.
1 minute, please.
Serial
Give
number
a date
12.
to him.
The 20th. Sorry.
Next,
Lord,
Serial
serial
number
number
12.
49, my lord.
one at a time. Yes.
Serial number 49, my lord. And for the appellant, on the last date, the TCR was called for, my lord, the trial court records. By reading of the cause list,
File your
doesn't seem.
Who appears for the other side?
I'm for the appellant, the
Present, my
respondent.
lord.
You file your submissions also.
Yes, my lord. My lord, if the trial court records may be again requisitioned for.
Just say this, submissions be filed by the counsel for the parties along with the judgments. Trial court record the requisition before the next date of hearing.
My lord, there's an interim order in this, if it may kindly be extended. My lord.
Interim order, if any, to continue. We call for the trial court record on the last date. Has not come, no?
2024.
Serial number 12. One date may be good. There we are going to argument.
Ma'am, no, record has come or not? Have received. We have received the record.
Obliged, my lord, it's not reflecting in the cause list.
Is
If
it-
that's the case, then it may be taken up on 17th, 18th of February.
No, we will give you, file your submissions.
Obliged.
Just give a date, ma'am, in 49.
Serial number 12. One date may be given. We will submit on merit.
No need, we'll just come back after lunch.
Number 45.
My lord, Supreme Court decision is there with writ jurisdiction, the arbitral jurisdiction. So one date may we will submit. with
Tomorrow,
that
we'll
is-
have it
Ah,
tomorrow.
yes, okay, okay.
Just have it tomorrow, that Passover.
Serial number
49.
Serial number 12.
My lord, serial number 43, my lords.
Just 1 minute, please. What, which was your number?
Serial number 12.
Well, just have it tomorrow.
Tomorrow may call.
Now, in your case, we have given the date.
49, my lord, I'm not.
Just give the date to them.
49, 26/3, sir.
Obliged, my lord.
Yes.
There's an interim order in that, my lord, if it may
Interim
kindly-
order. if
Serial
any to
number
continue.
43, my lords.
Obliged, my lord.
I'm for the respondent in this.
I pray for 2 weeks of time, my lords.
My lords, in this, council on
43.
record has passed over.
Huh?
Council on record has passed away, my lords. Chandrasekhar Patil.
Okay. At the request of counsel for the appellant, re-notify 43.
17/4.
Much obliged, my lord.
Obliged, my
Mention,
lords.
my lord.
Serial number 45. My lord, I have to file written authorities, my lord. I filed the memo of submissions. Only the citations I have to file.
Who is the other side?
But, my lord,
Just
I-
call him after lunch.
please.
My lord, Madam.
Even 6. No, but I'll text him at 6:30.
Who is the other side, Mr. Srikanth? Yes. Twenty-eight. Who is the other side?
No, notice.
They say the request of counsel for the appellant re-notify.
15-4.
Please call the matters, ma'am. Yes. Continue.
Serial number 42.
Lord, in this case, can I just seek for 2 days time till Wednesday?
Hey.
Today I have one parted matter is going on.
Day after,
Please,
at the request of counsel for the appellant, re-notify day after.
9-1.
grateful to.
43 adjourned. 44.
Here for the appellant. You know.
Passover.
45.
You will file submissions, Mr. Unnikrishnan?
Well, I have filed my submission, I filed translation, citations, everything I've done.
Let them file. Counsel for the respondents to file written submissions within 4 weeks. List of.
Can I make a submission, my lord? In fact, twice this matter had come up. Both were ready. Instead of 4 weeks, 2 weeks means we, both of us will go on.
Very well, 2 weeks.
2 weeks, my lord. Date.
25-2. Serial number 45.
For the appellant, my lord. No, the appeal has already been admitted. Has been admitted. We have filed a memo of submissions, my lord. We have to file authorities, my lord, which we will.
Who is the other side?
The but, my lord.
But
File your submission. You want to argue? Are you ready?
My lord, only the citations which I'm placing reliance on. Request a week's time, my lord.
Just say submissions be filed by the counsel for the parties within 4 weeks. Next.
11-3. Serial number 46. Manian.
Yes.
For the appellants.
Also directed to file, madam, because our submissions will depend on what the
These are not pleadings in that sense.
Yes.
Very well, whatever you want. Have you filed it?
No, we haven't filed a synopsis yet. But there is some urgency here, my lord. An award was challenged by both sides. And my lord, what has happened is in the suits are filed under section 34, the suit filed by the respondents came to be allowed on merits. The district judge virtually sat and appealed over the award, went through the issues, appreciated the evidence and passed a judgment as though he was sitting in appeal over the award. And that he has set aside the award and passed a judgment and decree in favor of the respondents. So we have filed an appeal challenging that judgment in a suit filed by them. Consequent to the findings in that suit, he has readily dismissed our suit, saying that it does not now survive in view of my decreeing of their suit. So this is how both his suit was decreed and my suit was dismissed. So we filed 2 appeals challenging those judgments. Now, my lord will see that he has filed an execution for enforcing the, for enforcing the
34 which in your favor.
the windfall. So that has to be stayed. Now, he can't have it both ways. Now, kindly see the way it is. Now, no, one minute. Now, my lord, we have preferred a stay application in both appeals. Now, so far as his suit is concerned, which was decreed, my respectful submission, my lord, there can be no 2 questions that the judgment passed by the trial court is untenable in law. And therefore, an execution proceeding in that proceeding cannot proceed any further.
They have submitted some judgment judgments, my lord, of the last day. We have produced one judgment where this question has been referred to a larger bench of the short passover will be granted. My signal.
But we will go by the present position now. Till such time that gets clarified. What is the present position?
Yes, my lord, but my only submission is this, my lord, that the Delhi High Court has also in the past held, the recent past, my lord, in the last 1 year, held that partial setting aside is permissible and it doesn't amount to modification of the award.
But here, what is it done?
A complete revamp.
Tell us one thing, what happened to your counterclaims or claims?
My lord, what had happened was this, I had paid interest-free refundable security deposit of 98 lakh rupees. And my lord,
What does the arbitrator say in so far?
the arbitrator has done equity by awarding 48 lakh to the appellant towards loss of rents, man. Despite arriving at a finding that
What on 98 lakhs, what did he say?
on the 98 lakh, 50 lakh was directed to be refunded to me, whereas 48 lakh was.
So he has done that. What does the 34 court say?
The 34 court holds that the 48 lakh could not have been directed to be.
So in a
refunded to
way,
the appellant, and therefore 98 lakh should be completely refunded.
he has rewritten the award.
Yes, my lord. My only submission is this, my lord, that it doesn't amount to a complete modification of the award.
Why?
Because, my lord, because it emanates from one claim, which is the refundable security deposit, as to whether I'm entitled to the.
See, he would set aside or approve it. There is no third option.
Yes, ma'am.
It is for the parties to work out if anything, they have anything. But today what did he do? Effectively, he has rewritten the award. That means your claims for 98 lakhs have been allowed. That's right. And their, this thing,
Challenge
whatever
to the
their
award.
claims were there, which were also in favor of them 48 lakhs, that has been set aside.
Wiped out.
That he could have done it.
Yes,
You
ma'am.
can imagine, you're right, that to that extent, he will say very well, A, B, C set aside. And A, B, C, D, F approved. That's all. He will not say anything else.
Let them not precipitate the execution in that matter where they are claiming a windfall.
Very well. Chalo, whatever is next, pass over.
47 adjourned, 48, Ananta Narayan.
Maybe taken next week, my lord, is some personal influence to the Anant Narayan.
Yes.
Maybe.
Yes, what is
Lord,
this?
This may be taken up next week, my lord,
Why?
because the Anant Narayan is not well, who is represent this appeal.
See, these are date given matters.
Next week,
You
any
can't-
date, my lord.
It's all right, please, we will
Please.
not. This is yes,
The advocate who is on record is not well, my lord. Next week, any date, my lord.
we have been informed that the counsel for the appellant is unwell, adjourned to, just give it normal date.
25 for 49 adjourned, 50. Manisha Kangovi, 50.
For the appellant, ma'am.
Yes,
My lord, my colleague on the matter is appearing through VC.
Unmute. Ask her to unmute her.
Oh,
Madam, serial number 50. Please unmute, madam. Madam, you have to unmute.
yes,
My lords, can
My lords, am I audible?
Yes, yes.
My lords, my sincere apologies. My lords, I beg to appear on behalf of the appellant in item 50. My lords, I appear from Chennai, my lords. If I can kindly request for a date to be fixed for the hearing, my lords, I'll come down and argue the matter in person, my lords.
But you have not deposited. Was there any direction to deposit the amount?
My lords, there was a direction to deposit the amount, my lords. Thereafter, I filed a memo stating my difficulty in making the deposit, my lords. The matter is ripe for final arguments. I'm ready to go on with the matter, my lords. If I can only request for a date to be fixed, I'll come down in person, my lords.
Have they filed any execution, enforcement?
They had initially filed an execution, my lords, but they've withdrawn it. I was given to understand they wanted to initiate another execution proceeding before the jurisdictional court in Kolar. But that hasn't been done, so I've not been served with
Very
any
well.
notice as of date, my lords.
We say nothing, just say that at the request of counsel for the appellant, re-notify.
22-4.
Very well, my
Yes.
lords. I'm grateful, my lords.
Yes.
Passed down matters. Serial number 3. Serial number 3, Shashidhar.
Yes. What is the position now?
There was a proposal for settlement from our side to the other side to buy the property itself, which is the subject matter of the suit. And my friend heard us and he tried, I believe, he couldn't convince his client regarding offer for acceptance of the offer. So therefore, virtually the settlement has broken. In the sense, there cannot be any settlement at all. The only option is that I should come back to do the duty of presentation of the case and invite the verdict of the court on the merits of the appeal itself.
Okay.
I have been insulated with only one thing, that is this hearing of the appeal on merits. I tried an option for a settlement, out-court settlement. I don't know, but there was no such good response from the other side, in the sense
At
they are
the
not
request
willing
of-
to
at
sell the
request
property
of
to me.
counsel for the appellant, re-notify.
Can it be listed after a date may be given exactly, because it's a very short matter where a decree for mandatory injunction can be equated with that of the decree for possession under the specific relief act under section 34. That's all the question that I have posed before the court, and court has to give a verdict on that. Decree for mandatory injunction can be equated in the facts and circumstances of the case to that of a decree for possession in absence of asking for it.
They give a date. ma'am.
26-3.
Next.
Please.
Serial number,
This too. May I know the date?
sir, 26-3, sir.
26th March.
Serial number 8.
By Mr. Srikanth.
Lords, for appellant in the matter, Lords, I may permitted to Lords produce Lords document.
What is this?
Lords, C&R rules, Lord, two C&R rules. And my lords, one document from the Kannada Sahitya Parishad, my lords, prescribing, my lord, that's a copy of the prospectus, which says that, my lords, PUC or, my lords, the JANA examination conducted by the Parishad as the qualifying examination for taking up Ratna. Lords, I brought to your lordship's notice, my lord, that they can join MA with that, and my lords, PUC being, my lords, the basic qualification to join the course. My submission is, my lords, that it is equivalent to PUC. But C&R rules, my lords, of 1991. Lordships have page number 5, my lords.
See, what you have to show is this, Mr. Sri.
Yeah, my lords, I would, my lords, but this 91 rules, probably, my lords, I missed out. My lords, if your lordships have, my lord, the page number 5, my lords.
Yes.
On the left-hand side, your lordships can find, my lords, secondary school assistants grade 2. That is, my lords, the second half of, my lords, the page 5.
The upper portion or the lower portion?
Lower portion, my lords.
Yes.
On the extreme right, your lordships can see, my lords, for direct procurement. I'm sorry, my lord, it is not that legible, but my lords, for direct procurement and for promotion. My lords, I'll skip, my lords, A1
And two, if your lordships come to my lords for language, must be a holder of degree in arts with any of the following major subjects. For this is for which subject? Please, Kannada. Which post? My lords, for so first the appellant, my lords, Kannada assistant teacher's post. Kannada teacher. Yes, my lords. What is for arts? My lords, it is called as, my lords, the arts that is a degree. If you lords say, my lords, that is small Roman 3. What is the designation we are concerned with? My lords, assistant teacher in grade 2, arts, that is Kannada, my lords. My lord, what happens is, my lord, there are several orders, my lords, which is issued subsequently, which says even those who have degree in arts with any of the following subjects, optional subject, economics, CAA, must have studied degree at the level of the language of the medium A. English, Kannada, Hindi, Urdu, so and so. Then, my lords, Kannada is there. For language teacher, my lords, Kannada. Subrule 2, my lords, in that. That is clause 2, I'm sorry. It says, in case of candidates who have not studied Kannada in the degree level, he must have studied Kannada as first or second language at SSLC level. Where are you reading? My lords, the page over at page number 6, my lords. My lords, if I have not studied as an optional, I must have studied Kannada as a language in SSLC. What does the advertisement says? My lord, the advertisement, my lords, it only says for. Let's go by advertisement. Yes, my lords, I would. Let's not add on to anything on it. I understand, my lords, I understand. Just show us the.
Page 81, my lord.
Come to page 81. Yes. It says arts teacher, BA, B.Ed English. Yes, my lord. BA post Kannada teacher, BA, B.Ed Kannada major or Kannada Pandit. One post for CMA boys and so and so within 21 days. Lord, my respectful submission is, not the qualification which is prescribed insofar as aided school, Lord, should be same as that of my lords, or my lords, any other even private school should be same as my lords, the government school. For a moment, let's assume that my lord, it is not there also. That my lord, the prescription of my lords having studied Kannada as a language, my lords, in SSLC level. If your lordships kindly, my lords, permit my lords to take your lordships to the provisions of the Karnataka Education Act. Now, what does the advertisement say? Advertisement says degree, with that is BA degree,
Or
and
Kannada.
as an optional, or Pandit. That's all. Yes, that's what, my lords, with that, my lords, in the background, I was trying to make this submission, my lords. My respectful submission is, my lord, the notification what is issued by, my lords, the government, my lord, the institution that cannot restrict, my lord, what the qualification prescribed by the state. Challenge. You should have challenged the advertisement. But the management proposes my name. That's more reason. Yes, in a way, you are a beneficiary under this advertisement. But precisely my contention is, my lord, that I should have been considered as per these. That's right. Please, where was the case set up? And we don't know what are these rules which are now sought to be relied upon. No such case was set up before the learned single judge. Lord, this matter, lords, was taken up, before the revisional authority. That's the instruction I have. Lord, we will go by advertisement, Mr. Srikanth. Please. You had applied under the advertisement. Yes, thinking very well that you are eligible under that. Please. That's right. Please. You have to show how you are eligible. That's all. My lords, I'll take 2-3 documents, my lords, and I leave it at the lords. Section 88, my lords. Is this one? Section 88 of the Karnataka Education Act. And tell us one thing, what argument you are now advancing is this, please. I have graduation, yes. Though I don't have Kannada as a language, but PUC, if I have studied Kannada. No, my submission is that Ratna, my lords, I'll take you lordships to the second document also. Where, my lord, they have specifically, my lords, recognized Ratna examination in the C&R rules. My lords, before proceeding to that, my lords, I had to justify, my lord, the qualifications, my lord, with regard to the question which was posed to me. my lord, as such, my lords, I am taking your lordships to, my lord, section 88 of the Karnataka Education Act. That it cannot be different from what the, my lord, prescription of the qualification, my lords, insofar as the government employees. Right, that goes
Please.
without saying.
Yes,
But now,
please.
what does this Education Act prescribes?
Section 88, my lord.
No person who does not possess the requisite cause 87 shall be, and from the date of commencement they are appointed as an employee. There's a
Section 87, my lords, the notification. One
It
second,
precedes with 87, my lord, and
one second, I'm answering that. Section 87, my lords, if your lordships kindly come to.
Yes.
That-
87.
Yes. ma'am. Note, the state government may, after previous publication, make rules regulating the recruitment and conditions of service, including rights as regards to disciplinary matters of the employees in recognized private educational institutions. Now, my lords, ultimately it is the power of the state, my lords, to prescribe the rules, and my lord, it is to be followed by, my lords, the private institutions.
That's right.
Please. Now, in that background, my lords, as a persuasive value, my lord, the very issue, my lords, came for consideration before a learned single judge of this honorable court, my lords. My lords, I could find out, my lord, this has become final.
What?
And the order has been
No,
implemented.
1 minute.
Please.
Now you take forward this
Please.
submission of yours. We want to know,
Please.
what was the advertisement that was issued?
Yes, my lord, advertisement says, my lords, BA, BEd with order major or other order, I mean, the Pandit course, insofar as the Kannada teacher subject.
Now, which are the rules which governs you?
Lord, this is the only, my lord, whatever is prescribed to the, my lord's state, my lords, till 1999. My lords, we were, my lords, following these rules only. In 99, my lords, that I'll take your lordships also. If lordships have, my lords, that clearly prescribes, my lords, as to what the, my lord, the prescribed rules would be while going for recruitment, my lords, in a private institution. If lordships are having page number 1267, 1267 in education.
But where is this BEd in this recruitment rule?
Please,
BEd.
the one lords which I,
No, because
please,
the rule says
yes,
science teacher, for arts teacher, BA, BEd, English language. You don't know, we can't read it. Diploma in English. Hmm?
then lords, B is a degree in education. Don't, my lords, below that, after 3, my lords, your lordships can see, must be a holder of degree in education.
Kannada teacher, BA, BEd. You are BA, BEd?
Yes, my lords, be a BEd.
Okay. Kannada major or Kannada Pandit, one post.
I have not studied, my lords, as an optional in degree. That's an admitted fact.
Kannada major or a Kannada Pandit. Okay. So what they say is BA, BEd, but you should be Kannada major or a Kannada Pandit
Yes.
of 4 years.
Yes, I have not studied that as an optional, but as a language, my lords, I have studied in degree. But 2 says if in case of candidates who have not studied Kannada at the degree level, he must have studied Kannada as a first or second language at SLC level.
But how this advertisement has been issued,
Please,
from where they picked up this language. But,
it says Kannada teacher, BA, B.Ed. Kannada major or Kannada Pandit. That's what it
just imagine,
please.
now, does this advertisement say that does this advertisement reflect that two which you are reading?
No.
It doesn't, nah?
No.
See, what is the effect?
My lords, if for that purpose, my lords, I wanted to take your lordships to the relevant rules, my lords, of the government, insofar as recruitment, my lords, as to what has been prescribed. If your lordships are having, my lords, 1267, my lords, page number, that is Karnataka Educational Institutions Recruitment and Terms and Conditions of Service of Employees in Private, Aided, Primary and Secondary Educational Institutions Rules 1999. In that, my lords,
Now, after 1991, these were framed.
my lords, I was
99.
appointed in 2001. The rules, my lords, came in force in 2000. By the
These 99.
19 in rules.
So 91 are no more in operation.
No, that's what I was trying to say. 91 is in respect to government schools.
Okay.
My lords, may have a look at, my lords.
Are we concerned with government schools?
My lords,
Yeah.
government aided schools, my lords. Aided,
Not concerned with government schools,
no.
aided schools.
Yes, my lords.
Okay. I don't know how there can be two different qualifications for government and aided and.
My lords, the rule says, my lord, it shall be as same as that of
Has to
the
be that
government.
way.
Yes, my lords.
Now, what is this 99 rules?
My lords, that is in respect of, my lords, aided, that is private, aided, primary and secondary educational institutions.
This
Applies to
governs,
me.
this governs you?
Yes, my lord, applies to me.
Okay.
Your lords may kindly come to, my lords, that is rule 3, my lord.
Yes.
My lords, if lordships kindly have, my lords, sub-rule 1, subject to other provisions in these rules, the categories of posts, the staffing pattern, and the qualifications for recruitment to post in an institution shall be specified in Annexure 3, 4, and 5. In respect of employees other than teachers, the prescribed qualifications for recruitment in the institution shall be the same as those applicable for corresponding category of employees in government educational institutions. That's as such, my lords, same applies here. My lord, with regard to that, there is, my lords, no dispute. That's what I was trying to say.
So
my
what
lords.
you are saying is 91 is applicable.
Yes, 91 is applicable to me. My lord, 2 should have been considered, my lord, is one issue. If
Now,
not,
what
please.
we are putting it to is,
please,
does the advertisement say about two?
no,
Now see the consequence.
please,
There may be people
yes,
who have similarly placed like you,
please,
who also had done PUC or SLC with Kannada.
please.
They could not have applied. With this quality, they could not have.
Possible, not, I'm not ruling out.
See the consequence.
Please,
But you applied,
yes,
not knowing two is there.
the other, my lords, I had to bring to this court's notice that, I mean, in fact, my lords, I was working in the same institution since 1995.
That's something which is serious.
My lords, that was, my lords, as a temporary, my lords, I was, my lords, maybe, my lords, on, my lords, if it is looked at, my lords, from the other, my lords, if it is looked at from one angle, from the other angle, there is clear exploitation, as he was not paid, my lords, any salary, and as was assured.
You are
Yes.
right. We are
Please.
also concerned,
Please,
when this ad was issued, why two was not reflected?
my lord, that's, my lords, for the management, my lords, to answer, my lords.
That's right. We are
Please.
concerned, but see, when we are considering as a court of
The difficulty is, my lords, as soon as I lost, my lords, before the revision authority, my management abandons me, my lords, goes for recruitment, my lord, permission is granted by the department. Another person was appointed. I also made him as a party, my lords. Ultimately, my lord, the petition which I filed, my lords, also got disposed of.
So, and to be very frank, this issue is only this, Mr. Srikanth. Please. A particular advertisement was, an advertisement was given in a particular manner. Please. Whether you meet the requirement in terms of the advertisement. That's all.
My lords, if I put it other way, my lords, they could not have, my lords. My lords, I can say, my lords, if any, my lords, qualifications are prescribed under any rule, my lords, the employer can, my lords, ask for, my lords, a higher performance. My lords, he can demand for higher performance. If it is, my lords, degree, he can say, I need a person with those who are secured 50%, 60% or something as such.
Yeah, yeah.
But he cannot say, for a moment, my lords, with great respects, that I leave out the qualification what is prescribed. That is not.
You're actually right. You are right on that.
Please,
But we are putting it to you this question.
please, ma'am.
If they had included two also, which
Please.
was is your case,
Please.
others could have also applied.
My lords, at this length of time, my lords, after almost, my lords, 24, 25 years. My lords, the
That's
difficulty.
right.
Yeah,
So we have to balance the public interest.
please,
Public interest. Two could have inured to your interest.
please,
Two could have inured to your interest.
please.
It could have allowed others people also to apply,
Yes, ma'am.
and there would be a consideration pursuant thereto.
Please,
It never happened. Two, they did not prescribe, so you could not inure to your benefit. Neither it could inure to the benefit of the people at large who may also have qualified it.
please.
So how, what do you say?
My lords, with respects, my lords, the issue is, my lords, my lords have been agitating throughout. My lords, the case of the other side is that, my lords, they don't speak of
Just
this.
wait.
They only
What do
stop.
you- Just
Please.
one. What do you have to say?
My lord, firstly, I have
My lords,
to,
just to assist the court, my lord, this issue was considered by my lords, a learned single judge of this honorable court. My lords, I'm informed that, my lord, this order has become final. If your lordships come to my lords, page number 4. Second line, not start with the Joint Director of Public Instruction by its letter dated 27/2/19 and had informed that there is one vacant post of Assistant Master Kannada. And since the approval was sought in respect of Assistant Master Arts, and as there was no indication that the petitioner had studied Kannada as an optional subject in BA degree, the proposal could not be considered and it was rejected. It is erroneous impression that the petitioner has sought for the question. Therefore, he made a representation to indicate that the petitioner indeed passed BA with Kannada as the second language, and therefore the rejection of the proposal on the ground that the petitioner had not studied Kannada was erroneous. In spite of such representation having made as early as 3/7/2001, there was no further recourse. It is in this background that the management of the petitioner had repeatedly made representation to the Joint Director to reconsider the earlier rejection of the proposal of the approval of petitioner's appointment as Assistant Master Kannada instead of Assistant Master Arts. Those representations not having been considered in spite of repeated follow-up, the petitioner is before this court. There is delay on the part of the petitioner in approaching the court. The representation had been made in 2001 and the petitioner has thought it fit to approach the court in 2008. The petition would have to be rejected on that ground having regard to the inordinate delay. However, the facts narrated here and above and the document produced in support of those contentions would indicate that there is an error apparent in the authority having held that the petitioner had not studied Kannada as an optional subject in his degree, and therefore the respondent authority ought to have reconsidered the issue, reconsider the case of the petitioner for such approval. And it is inexplicable that the same has been kept on board without any further consideration for such long period. Therefore, the petition deserves to be allowed. The learned government paid a 6 time to file statement objections, so on, so on. Ultimately, it is allowed.
But how this is helpful to you?
The
1 minute.
please,
This also proceeds on that premise
please.
that for graduation, there should be an optional Kannada. That's not your case.
No. This is, my lords, there was no optional, but he had studied as a language in Kannada, language Kannada in, my lords, in the degree.
In degree,
Yes,
where have you studied?
I have, my lords.
Huh?
I have studied, my lords.
Kannada as a Kannada?
Yes, my lords. I have the certificates produced, my lords, before the court.
No, in degree.
Yes,
if lordships have my lords, the certificate. But it's not a major. No, it's not an as, my lords, it's not as an optional. But my lord, the languages are prescribed, my lords, in degrees, my lords, up for first and second year. But it says a major, no? It says as a major. No, it was rejected because it was not major. That's the endorsement issued by the deputy director. That's right. Please. So that means the converse of it is, it should be major. Correct. As a language. Right. Please. As a language. As a language, my lord, yes, I have studied. As a major.
No. Major is different, language is different.
As a major. See, the recruitment rule says major, Mr. Srikanth. My lord, see the rule.
Like history, economics, Kannada.
For language, please, must be holder of a degree in arts with any of the following major subjects. Yes, that is optionals. 2 is in case of candidates who have not studied Kannada at the degree level, he must have studied Kannada as a first or second language at SLC level. If I have not studied Kannada, then SLC is okay. That's what the rule says.
My lord, if I may submit.
As an optional also. If I have not studied, then yes. But you say you have studied Kannada as an optional. As a language, my lords, in BA, studied, my lords, SLC, at SLC and PUC level, my lords, these subjects. No, something in your favor. Please. Must be a holder of a degree in arts with any of the following major subjects. Yes. As optionals, namely English, Kannada, Hindi. Yes. Okay. So what you say is, we have not understood this word usage of the word major and optional both.
Both are same.
My lords, in some of the, my lords, at that time, my lords, earlier, my lords, what happened, what used to, my lords, be the case is, in so as Bangalore University is concerned, my lords, we had 3 optionals. Whereas, my lords, in some of the universities, we had 2 major subjects and 1 additional subject. Correct. Those 2 were called as, my lords, major. What is your understanding of the rules? You should study graduation in Kannada, or I should study one of the subject Kannada. If it is not, then SLC can be considered. Suppose for a moment, please, I am doing BA history, please, honors. I have a Kannada as an optional subject. If, my lords, Kannada is an optional subject, there is no dispute about it. But if, in so far as the case of the appellant before your lordships, his my lords, he has not studied, my lords, the language as an optional. That's the whole difficulty. What do you mean by these following major subjects? Major is surely not optional. No. Among the optionals, my lord, there will be 2 major subjects, one
Kannada
additional
as a
subject.
language. Along with the major, he should have passed Kannada.
Kannada has a major subject. It is not studied Kannada at all, then SLC can be considered. You study. So you studied Kannada in graduation. Kannada as a language, my lords, from SLC, my lords, I studied Kannada as a language. No, at the graduation level, have you studied Kannada as as a language, my lords, I have studied, not as an option. What is optional? In so far as, my lords, the optional is major. My lord, your lords may, my lords, my lords, of 3 years course. My lords, first year, my lords, 5 subjects, 3 optionals, 2 languages. Second year, my lords, similar, my lords. Third year, only optionals. In Bangalore University, that's what I was trying to say. Let's understand what is the language he has studied. What is the graduation he did? My lords, I'll start from, my lords, SSLC. My lords. I have produced the certificate also.
Graduation.
What is the graduation he has studied? Graduation, my lords, Kannada, my lords, I have.
Major subjects.
My lords, that is
Economics.
and geography.
Economics.
History, economics, sociology, and political science.
No, only 3 subjects.
Yes. As German, the optional
Page,
not have studied.
58 only.
If
Ma'am,
not
just
just
tell us,
you have the mark sheet of his.
Yes, my lords, at page number 58.
58 is his pre-university education mark sheet.
So the impression we got,
Please.
which surely I got, was he did not study Kannada as even as a subject.
No, no,
He studied Kannada as a subject.
Huh.
However, my submission would be, firstly, I should commend the stamina of the appellant to come before the court and agitate. And secondly, my lord, over here, my principal submission would be the specification given by the government with regard to Kannada Pandit or Kannada optional is mandatory. So that cannot be circumvented or cannot be diluted
You're
at
right.
all. And when the appellant herein says he's got Kannada Ratna, that isn't recognized. So this is a mandatory requirement by virtue of a notification given by the government. That is one. Secondly, my lord, as per the advertisement that we have already seen, page 83, 82, we have specified it has to be Kannada teacher B.Ed or Kannada Pandit again. Then when we go to page 83, that is annexure R, which is the appointment letter given by the Central Muslim Association of Karnataka, that is where he was working. The appointment letter, if I may read, which is dated 22/3/2003, the appointment is subject to the approval of the Department of Education. Now, for a moment, we cannot forget that this is a grant and aid position. So it's not a right which he can ask for. It is at the discretion of the government. So when the appointment letter itself stipulates that it is subject to the approval of the Department of Education, and he has accepted it, at this point of time, he cannot come around.
But you're right. But surely you will not deny him the appointment if he qualifies.
If he qualifies the mandatory.
That's the test.
Yes. Now, he is claiming for equivalence. Now, even for equivalence, my lord, the premise on which equivalence can be given is also the prerogative of the government, wherein we issue a notification and say, okay, Kannada Ratna is equivalent to so-and-so and so-and-so.
You're right, ma'am.
There is no notification to that accord.
Kannada Ratna is not there. The
Yes.
argument which he advanced on that day is different from what is being advanced now.
No, that is also there, my lords.
He is also.
Please,
Because we have heard
please,
you on
please,
that.
please.
Now, what is being said is on the basis of this rule.
Yes.
Okay. Now, first we want to know this rule is the rule which governs this appointment or eligibility.
So in fact, my lord, had placed the 2003 CNR rules. Now, what is brought before your lordship over here as part of additional documents is the 1999 rules, which he says.
91.
91, sorry. 91 rules. Over here, the language import, which is different than that which is in 2003.
Which is that rule which you relied upon?
I
Page.
had forwarded this CNR rules the last time, my lord.
Lords, the specific contention was that was notified later and has no application to the case.
Okay. Okay. Now, we just want to know that was, I think there was an issue also before the learned single judge. It was, this appointment was in January 2003. And these rules which you have relied upon were of March,
2000, yes.
2003 March.
Yes,
So he said there is
pursuant
no
to his appointment, so he relies back on the one he has. forwarded,
91 rules.
91 rules.
Yes.
Now, the only
Judge, my
language.
lords appreciates that contention but dismisses because I have superannuated. My lords,
No, no, no.
attained the age of
You will see that's
Please.
another limb you have to hurdle, you have to cross. We'll
No,
come
but
back.
all along, my lord, if we look into the judgments right from page 126, that is the appeal before the Directorate of Appellate Authority, the Appellate Authority has examined this aspect about the CNR rules, about the equivalence. If I may just take your lordship, so all these
No,
aspects,
we want to be, you're
Yes.
right. The case was not set up on the basis of these rules.
right,
It was never been his case. This is Mr. Shrikant's, I think.
ingenious.
Yes, now he is putting up this case. We will test that also.
Yes.
But since that issue has been raised before us, we want to consider it.
Yes,
See,
Yes.
what is being said advanced is this, that let's assume for a moment, he doesn't have Kannada as per this recruitment rules as an optional. Now he is trying to rely upon the second limb of the recruitment rule, which says if a candidate has studied Kannada, has not studied Kannada at the degree level, he must have studied Kannada at the first or second language at the SSLC level, which according to him, this was never the case which he had put up before the learner single judge.
Precisely.
But his case is, I did study at SSLC level, and these are the recruitment rules possibly framed under Article 309
Right.
or maybe under the provisions of the University Act,
Right.
and has a statutory flavor.
Yes. Yes.
Now, if this is so, what his argument is, the advertisement was contrary to these recruitment rules.
But he didn't challenge that. He didn't
At-
even challenge the appointment order, which said it is subject to the department giving its final approval. So now he's stopped of raising this kind of contention, is my humble submission.
You're right, you're right. That's what we have put it to it. But his argument is, there cannot be any appointment contrary to the rules. One, he says that when I fulfill the recruitment rules, your plea that he is not eligible goes. His argument based on this, your plea is what? He doesn't fulfill the qualification. He says, you see these recruitment rules and I fulfill it. He says, now you consider it from a different perspective. Ma'am, you will just give us a minute. What we have put it to him is this. Let's assume he fulfilled the recruitment rules. When the advertisement was issued without that SSLC stipulation.
Yes.
It was not there,
Yes,
part of
yes,
the advertisement.
Yes.
What we are saying is, if the advertisement was issued in terms of these recruitment rules, those people who have not done Kannada, even in the graduation
They are
level,
denied of
but
that.
they had also done it at SSLC level, they
Precisely.
could have also applied.
Precisely, my lord. So it is, as a state, we have a public duty. And if an advertisement has been given, put across in a paper, that applies to all in general. And in fact, the Supreme Court recently, my lord, with
No,
regard
one
to
minute.
this.
His argument is, sorry to interrupt you. His argument is, I have applied. They have not applied. I got appointment. There is a recommendation in my favor.
But then you go as per the advertisement and the appointment letter. That's my only submission. And now it can't be, the cycle cannot be turned back.
Okay, fine. Yes, Mr. Shekhar, we have heard her now. Now make your submission.
But the submission of the other side is it is made subject to the approval of the department. What is challenged is not the refusal to approve my appointment. It's not that I am challenging termination without challenging rejection.
Tell
I'm
us one
challenging
thing.
rejection.
Did you challenge your appointment or the advertisement based on this recruitment rule? Yes or no?
My lords, I raised a challenge that notification also I produced before lordships, my lords, where the Ratna examination is recognized by the state for the purpose of recruitment.
Recruitment or
Yes,
MA?
My lords, 9th August 2001 document.
Which page
My lords, there starts from page number 7.
of?
My lords,
This-
this
one?
yes, my lords. My lords, while dealing with my lords, the primary school assistant masters and teachers, at page number 8, my lords.
This is 2001.
Yes, ma'am.
How many recruitment rules are there?
My lords, insofar as my case, my lords, I go by 91.
Then why are you showing this?
To show that, my lords, it is there, it is recognized qualification by the state.
We will not. We will only look at the recruitment rule.
Please, my lords, if in that circumstance, my lord, my respectful submission is, my lords, that my lords, if lordships, my lord, there were my lords instances, my lords, in addition to my lord, the 91 rules, my lord, there were instances by this, my lords, from the, it is not that, my lords, as on the date only what needs to be considered. In many cases, the state, my lord, after approving their appointments, has given, my lords, some time for them to acquire the requisite qualifications.
No, that is a different.
No, what I'm trying to say is, my lord, there cannot be any differential treatment. In the instant case, my lords, by the time, my lords, the endorsement of my lords, during this, I completed MA also, MA in Kannada. Their cases, yes, you are entitled insofar as MA is concerned, but the fact is you have not studied that as an option. That's where, my lords, the whole problem lies. That's why, my lords, what I'm trying to say is,
when you can give time insofar as other persons, even after approving. My lord, this honorable court has considered that and said, even in the case of other persons, it should be done. My lords, that said, the additional qualification of MA, my lords, which occurred later, that could also, my lords. When did you acquire? My lord, the certificate, my lords, also have produced. In fact, that was one additional contention, my lords, which I took, my lords. Which year you acquired? My lords, I'll show my lords. That is in 2009, my lords. But why did you acquire? Lords, maybe because of this impediment for this appointment. I thought, my lords, I was probably, my lords, that time, my lords, she was advised that when he should get it because he can solve this problem. It's but then that goes against your own argument that these rules which were you are relying upon is of January and then what I'm trying to say is, if you say that I am not eligible as on that date, certainly you could have considered my case because it was subsequent. And my lords, to the query of this honorable court. But tell us, what is the criminal case going on against you? No, nothing. Is there any criminal case? No, nothing. Who had mentioned someone on may not be this?
Not this case, my lord.
Okay, very good. And not this, maybe we are getting confused with the other.
There's another case wherein, there was another case wherein they said there is some ಇನ್ನೊಂದು ಕೇಸು. ಈ ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ದವರು ಇವರು ಇನ್ನೊಬ್ರು ಇದ್ರು
No, in fact, my learned friend appeared.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನಡೀತಾ ಇದೆ.
No.
ಇಲ್ಲಲ್ಲ.
No. Okay, no. My lords had a query, my lords, about the language and my lord, the optional. My lord, that is clarified, my lords, in annexure T, my lords. Page number 90, my lords, is in Kannada. My lords, the deputy director, my lords, writes to the director seeking for clarification. If lordships kindly have, my lords, English translation at 95. Of the paper, appeal paper book? Appeal paper. And when did you attain the age of superannuation? My lords, in 2019. I think 2019, my lords. 19. During the pendency. And after, when you were not given appointment in 2003, you did not work thereafter. My lords, 2008-9, my lords, I was relieved of my duties by the management. Oh. Another person was, my lords, appointed as the permission was given by the department. Oh, they had appointed someone else. Yes, he is also party, my lord. The matter was, my lords, before the authorities and the court. Okay. He was a party here. Yes, for Jalil. My lords, RB Jalil. See, management and my lords, the Jalil Saab, who is appointed in my place. My lords, what is his name? Jalil Saab, RB Jalil Saab. Yes. Okay, then he continued on your post. Yes. And he is still working? Probably, yes. He is younger to me. Now, if we have to give you appointment, please, we have to dislodge him. That is yes or no? Yes, ma'am. Yes. Now tell us, after so many years of service, please, what will be your take? My lords, I have to be, my lords, compensated, my lords, by way of my lords back wages. Though I cannot be, my lords, reinstated, my lords, since I have attained 60 years of age. That's the only relief. Annexure T, my lords, I'll just show.
Let him agitate this.
Yes, my lords, my lord, the letter of my lords, the deputy director says clearly, my lords, that I had studied, my lords, the BA degree, my lords, from the Mysore University with economics, political science and geography and Kannada as a language. And that, my lords, I have studied, my lords, in vide, my lord, the Kannada, my lords, Kannada methods. Difficult, Mr. Srikanth. Lord, not in these facts. The only thing you have explained is the delay on which the learner single judge has rejected it. Please, possibly, there can be something to say what you have said also. So, Please, it's not a case you were sleeping over your rights. You were before one or the other authority.
Yes,
So that explains possibly the delay and laches, if any, please. But on merits, I don't think in this fact we should take it further.
Lord, the only, Lords, the contention of the other side, Lords, they don't speak of, Lords, the 91 rules or, Lords, they
That's
don't,
right.
Lords, get into that question at all. What they say is recruitment, the rules which came subsequently, the amendments which came subsequently, will not be in, will not be in a position considering that to approve your appointment. That's their case. Lords, that cannot be, my lord, the situation, Lords. That's a difficulty I'm facing from that
Very
day.
right. But the only thing which we
Please.
can take against you is this.
Please.
Surely in terms of advertisement, strictly going by the advertisement, don't go into the rules, please. Strictly going by the advertisement, you are not eligible.
Lords, I'm afraid, my lords, that
Yes or
cannot,
no?
my lords, in
Yes
other,
or no?
my lords, if for my lords, any other thing, my lords, I cannot.
Not answering yes or no.
My lords, I beg to differ, my lords.
Oh, that's a very political way of saying no.
My lord, the difficulty would be, my lords, if, I mean, I cannot have, my lord, they can insist as, my lords, with repetition, with, my lord, with the, they cannot prescribe always higher qualification. That, my lords, if that is so, probably I had no case at all.
I had a case, possibly, if you are relying on 91, we must say so. We must say so. That case was never put. We don't know why advertisement was put that -2. Okay, we have spent a lot of time, Mr. Srikanth.
My lords,
I don't think-
my lords, my lords, I'll just produce the authorities and, my lords, leave it at that, my lords, tomorrow morning, my lord.
What authority, tell us?
Just, my lords, to show that, my lords, they have to go by the rules, my lord, not the,
That's a settled
Please.
position of law. This is the only proposition.
my lords, on, my submission is that they should have considered, my lord, the rules, which were, my lords, asked to be considered, my lords, by the
Very
authority.
goes without saying that they have to follow recruitment
Please.
rules, but they have not done it. You have also not challenged. Very well. In any case, we'll
Please.
pass orders. We will, oh, this is your appeal,
No, my
No,
appeal.
no, no.
your appeal. Huh? We will
In-
dismiss the appeal.
You know, in fact, my lords, so I took that contention, my lords, before the revisional authority, that I should have been, my lords, considered for the recruitment. That is, my lords, not touched upon by the, unfortunately, by the authority.
See the another aspect, that's what we are saying,
Please.
see the injustice, or we won't say injustice in that sense,
Please.
because there may be at least a shade of injustice at your level, for you also, against you
Yes.
also. But the fact remains, now we can't dislodge him.
My
For
lords,
you to give
my lords,
the appointment.
my lords may have a look at, my lord, the, my lords, I'll just show, my lords, the input, my lords, before the learned single judge. My lords, Annexure A, my lords, 158. Just to show that, my lords, I have raised that contention. The prayer, my lord, second
Page,
prayer, which,
page.
my lord, the order of the authority starts at 158. my lords. A prayer, my lords, which is sought, my lords, has been extracted, my lords, in English itself. However, my lord, the other portion is in Kannada. That is at 160, my lords.
Appointment of Kannada teacher at Bangalore.
Bangalore of respond and direct respond to approve his appointment as per government letter so and so dated 23/8/2000 as per 1991 C&R rules. Specifically, that was the case, my lord, which was put forth.
You are right,
Yes,
161 actually answers that.
he say, my lords, he goes on the tangent, my lord. Subsequently, there is an amendment. That amendment was brought subsequent to my appointment on 24/6/2003. My lords, is the amendment which is brought in, amending, my lords, 91 rules.
Where is that?
My lords, that is the date itself, my lords, they have, my lords, provided. They say, as per, in fact, my lords, my learned friend also made available, my lords, that notification. That is dated 24/6/2003. My specific case was, my lord, that has no application insofar as my case, because I was appointed prior to that. Thus,
Okay.
that's the ground on which, my lords, I approached, my lord, this honorable court by filing a writ petition.
All these issues
Thank you.
have been
Will
looked
not
into.
in this fact, Mr.
My lord,
thank
as a
you.
persuasive,
Will pass orders.
as a persuasive effect, there is one judgment wherein it speaks about equivalence of qualification, and also when a state engages in employment and makes an advertisement, there is a public duty cast wherein equal opportunity to all. So if your lordship, I just have,
But today he is not now pressing that.
yeah, no,
He is going on a different line.
true, which were not part of the pleadings before the learned single judge. But however, I mean, the
Give us
stamina.
that judgment. We look into it also.
Please.
Just say we'll dismiss it, we'll pass orders.
Tab,
Please.
65
Your
and
lordships also may
67.
consider, my lord, the argument which I advanced on the other day about Ratna qualification, my lords.
We'll do also everything.
Please,
We'll
please.
do everything. Okay. Dismiss. Please, we'll pass order. Thank you, Mr. Srikanth. Thank you, ma'am. Publish.
Much
Next.
obliged.
सारे काम छोड़ के आगे तैयारी यार मैंने कहा क्या ब्लंडर है ये
Yes.
Serial number 18. Serial number 18.
For the petitioner, my lord, sir, I seek for a passover, my lord.
Please, apologies.
Who is appealing?
Mr. Muttanna, my lord.
Just see pass over. Let's see if he comes.
Very well.
Pass over.
19. Manjunath.
For the respondent, before my learned friend begin, my lord, my subject, this is a appeal against the order dismissing the miscellaneous petition, my lord. The suit was decreed ex parte and they filed a miscellaneous petition. Miscellaneous petition is dismissed, against which appeal is filed.
Is it 913 under order 9?
Yes,
Rule
Lord.
13?
Order 9 Rule 13. So therefore, your lordship may have to look at the order sheet of the trial court to understand whether really the notice was served. I didn't find, they have not filed that order sheet before this court.
Please,
Otherwise, we can file it.
let's the,
But did you contest that 913?
please.
Yes, ma'am. Yes.
But you didn't contest on this ground.
My lord, I have contested on the ground that it is served, in the sense there is a deemed service of notice.
Very well, you checked up. Is the TCI here, man? No. We'll call for the TCI.
Yes, ma'am.
But I don't think TCS is required.
Not-
Page number 43 being seen, my lords,
43.
of the appeal memo. A judgment of the trial court has been annexed.
Yes.
Para number 3 at the bottom. On issuance of suit summons through RPD on 2 occasions, same were returned with postal shara as company closed. For the plaintiff got issued summons to the 3 various addresses of defendant. However, all this summons returned with postal shara as company closed left no such address respectively. These were the sharas, my lords. Based on this, I was placed ex parte and ex parte with judgment was passed. And thereafter, order 9 to 13 was came.
But did you change your address?
Please, my lords.
So then you don't inform them, what will they do?
Lords, I was not aware of the filing of suits, my lords.
Not necessarily. At least they will go by your address in their records and they implemented you. So you're getting the one. See, in a perspective,
My lords,
no.
pre-institution of suit, no notice were given to us
Where will they give you?
for
The
recovery
one
of suit.
address, one address they have, you are not at that place.
Lords, if I had an intimation of the recovery suit or the notice, I would have not got to know.
Right. We are putting it to you. Just see in normal circumstances.
My lords, as a
we-
prudent man, I should have given the address, but I was in a bad debt. I couldn't inform him.
That's the reason we don't say anything, but the fact remains, look it from their perspective. Now you say it was an ex parte, I was not served. Where will you be served? Now he made bona fidely all attempts. He's tried to serve you the address on the address which he had.
Please.
He gave 3 more addresses.
My lords, it was filed in the same plaint itself, my lords. 1 is my residential address, 2 is my office address.
You left all the places.
Please.
What will they do?
They ought to have taken paper publication. That was not done. Order 17 and order 5 rule 17 and 18.
How that
was
would have
out.
helped you?
My lords, I would have,
Tell us.
if someone would have stated that there is a
Just
suit against.
Give me one case where paper of publication has been issued and the respondent has appeared based on that paper publication. That's a formality, that's all.
Please. Please.
So very well. In any case, how much is decree for?
2 crores odd, my lords. 2 crores
What
27.
do you say?
Let's have made,
See, and mind it, today he has a money decree against him.
please.
You have filed execution?
Yes, my lord.
We have not asked him, we will put it to him. What if you say, and you have putting it to him, you must know, if he deposit all the decretal amount,
My lord, with terms, my lord, I may concede, my lord, that if they
we will
deposit the entire money
we
before
will
this court.
deposit and we will set aside,
Yes,
work it out.
Yes, my lord.
Well, it's already at 53 lakhs has been paid to him.
2 crore 77 lakhs is the decretal amount with interest, my lord.
Well,
This, you will argue this, look here, I paid 53 lakh, that has not been considered. Neither they have averred. At least you will get it reduced by 53 lakhs.
please, my lords,
To that extent, you will succeed, you'll work it out.
please.
No? So whatever is the decretal amount, you will deposit in the court concerned, we will set aside, subject to outcome of the proceedings. What do you say?
Yes, my lord.
A
But
sh-
the
a
this
short,
court has directed him to deposit the entire decretal amount before this court. He did not deposit. Therefore, my lord, I filed an application seeking injunction, restraining him from alienating the properties which belong to them. Your lordships have granted the interim order. So therefore, now if he deposits the entire money, I have no objection, my lord. Let there be an opportunity given to him. I will contest the matter.
well, it's a short accommodation. I'll seek
Take
instructions to the party.
instructions. Take instructions,
Please.
because he has a money decree and surely it is not something that for something which was unforeseen, you were not served. They have done, going by this judgment, they have taken all measures to serve you.
Well, it's interest parts of the judgment and decree could be.
My lord, Other factor is, my lord, other factor is, that he has issued checks for the amount. Checks got bounced. I initiated the proceedings under 138. 138, he represented, appeared before the court. I produced this plaint 1 year before the decree is passed. He did not appear before the commercial court. So therefore, he had the knowledge of the suit. It is not as if
It's a date
he
of,
did not have the knowledge.
my
He
lords,
deliberately avoided to contest this matter.
there are various judgment, my lords, where it says it is not for the date of hearing. It has to be served.
But then we will say you take instructions, whatever we have put it to you. Decretal amount deposited, you will proceed, we'll set aside.
Yeah.
And we will ask them not to be released to them
Yes.
till the suit is decided.
A short accommodation.
Very well. Just say that, we say nothing, we'll just simply re-notify, just list on,
Maybe on second week of February.
to enable the counsel for the appellant, take instructions. Okay,
My lord,
A date
interim
be
order
fixed.
may be extended.
interim order, if any, is extended till the next date of
A
hearing.
date be fixed, my lords,
Yeah, we are fixing a date.
please.
Into
Great.
What is the interim order?
Not to
That's-
alienate or encumber the proper schedule property.
That is for you.
Yes, it's for me. my lord.
And-
It's for me. I have filed an application because he did not deposit the money. Your lordship granted the order on
Show
IA
me
number. IA number 1 of 24. Dated 11/11/24.
They will not alienate
Yes,
any
please, yes.
interim orders if any to continue till the next date of.
Much.
21. Number 21. Sri Rahul Karyappa.
Yes,
IA number 1 of 23 is for the limitation, my lord, on continuation of delay of 23 days.
no, but what is the case on merit?
My lord, suit for recovery of money, my lord. There were several invoices raised by the respondent, and those invoices, whatever the defective, we have taken our contention that those with respect to certain invoices, those are defective products, and we have asked them to take back the products and
that products will be returned also, my lord. But they have not taken back the products with respect to invoice number 155, 160, 160, 74, 175, 176, and 57.
No, you
That
were
is-
ex parte before the. No.
No, no, madam.
Contested.
Contested.
Yes.
There was one document that we had relied upon, that is Exhibit D2, wherein they had acknowledged that the products which they had supplied for us were defective. And they, despite acknowledging the defect that they had produced or given, they failed to take back the products. And we had produced with using those chemicals, we had produced few our products, and we had supplied to our customers. And for which we received back the our customers, we received the feedback, also the products from few of the customers, saying that your products are not in good condition. Please take it back and return our money. So we have also incurred loss. That is because of the raw materials which have been taken from the respondents, my lord. That is the defense we have taken. And with respect to the admitted amount, my lord, admitted amount is already deposited before the trial court in execution. So that amount they're seeking for release in IA number 1 of 2024. Disputed amount comes around 10,26,000 rupees. We are contesting on that, my lord.
Lord, kindly see the page number 14 of the judgment, Lord. Under the invoices have supplied the materials. He admits that all the 13 invoices, the only dispute is in respect of invoice. Only one invoice dated dated 30/11/2019 for rupees 2 lakhs. Out of 56 lakhs amount the chemical supplied, the only dispute is in respect of 2,80,000.
Where is your D2?
Lord,
Where is D2 exhibit?
in my appeal
Is
memo,
the
I have not
file
produced
here,
that
no?
document, my lord.
File has not come. Where is D2 and exhibit D2?
Exhibit D2, I have not produced in my appeal memo, my lord.
Could have produced it.
It's a confirmation letter.
Just said, no, what does it say? Is a copy with you?
I have the
Sure. That.
those materials were disputed. I have produced photographs of the cans which are lying in my godowns also.
By this document you have disputed?
Yes, my lord.
Where do you say so? This is basically confirmation of accounts. Where is document?
All the transactions admitted in the confirmation letter, my lord. Let's kindly turn to page.
Tell us one thing, did he dispute the quality of the material?
No, my lord, no dispute with respect to, the only dispute is in respect of one invoice for 2 lakhs that we have replaced. The Lord, kindly turn to page number 15 of the judgment, my lord.
So that was not considered by the lower court also?
The trial court has considered page number 50, Lord, kindly turn to the judgment, my lord.
50?
Page number 15, the paragraph 19 end, my lord. It is last 3 line, my lord.
It is undisputed fact that the material supplied under invoice number 123 dated 30/11/2009 amounting to rupees 2,18,972.60 as per statute is returned back. This is the only invoice. They say that it's a defective. I returned it. Now let's kindly turn to page number paragraph 14. my lord.
Written back by whom?
By
them?
me. I have, they have returned it to me. I have supplied another material.
Where is that exhibit?
That exhibit
By which exhibit you dispute the material? Did you dispute all the material or only in one invoice material you have disputed?
Lord, we have disputed with respect to invoice number 155, 160, 174, 175, 176 and 57.
Where do you get that? Now, paragraph 19, he only refers to one invoice of 123.
Yes, my lord.
Para 14, my lord, it says everything is admitted, my lord. Para 25, my lord, of the judgment. Para 25 of the judgment, there is a clear finding that the entire transaction is admitted, except that para 25 of page number 21.
Where do you dispute? Where is your written statement?
My written statement.
Where are the issues? What were the issues framed?
Page number 11, my lord. Whether the plaintiff proves that the defendants are jointly and severally liable to pay rupees 69,28,500.
Whether
Page
the
number 12
defendant
of
prove
the
that the plaintiff is has supplied quality organic petrol and raw material product. Now, where is the basis? Where is your written statement? Now, let's see what does he say, the district judge. Defendants filed written statement stating that the suit is non-minimum either the defendant or regular customers. The organic petrol and raw material products supplied by the plaintiff was detailed by the defendant for manufacturing of the good coating and the thinner. The plaintiff and the
page
defendant.
21, 22, there is a findings of the court regarding the quality, my lord.
Sudden hike in the prices. The things to the plaintiff regarding hike in price without relying on different quality of argument, product defendant deny this in.
Para 21, my lord. There is a clear finding that about the defect, alleged defective of the
What have you, where are the invoices of 155, 160, 174? Have you filed it
No, my lord.
before the court?
Before the court, we are not.
Before the lower court also?
No, my
You have not filed? Then how will you prove it?
lord, because most of the transactions, what was happening between the respondent and the petitioner, my lord, those were all on oral basis, my lord, most of them. But on documentation, my lord, they admit that the purchase number 123 was returned by them, was taken back from them. They admit that.
But you tell us, how would you prove that certain material was defective? How would you prove? You
That
have to,
based-
you
based
have
on-
to show na, that this material, you have bought the material for this amount. It was proved to be defective.
Yes, my
The
lord.
carpenters were returning it back. You have suffered this much.
From exhibit D8 to D33, we have produced documents which we have returned it back. Our customers who were there, the carpenters were there, they had given us the products which were defective in nature. That was the only document which have
Which exhibit 8 to 33?
8 to 33.
What does the learned trial court say?
Para 22, my lord. That pertains to the sale of the chemicals to third parties, not pertaining to retail. Lashma Kenley, paragraph 22. Further, the defendant contend that the defective wood coating polish thinner manufactured by them have been retained by its customers. In this regard, he has produced exhibit D8 to D33 to show that the defendant customer has returned the goods due to the quality issues. On the contrary, admitted that these exhibit D8 to D33 invoices are pertaining to the sale of the chemicals from one SN Chemicals to GR Chemicals. In all tax invoices, GST is also included. But on the perusal of D8 to D33 does not disclose that these tax invoices are raised for return of the goods by the defendants. They produce the tax invoices for in respect of some other transaction that they have supplied to third parties to show that these are the under invoice they have returned it. There is a clear finding that those invoices are not pertaining to these transactions. Para 22.
My lord, under the GST, my lord, whenever they were supposed to give back the money, they had to include everything. The tax from right to tax from the return of money. So they raised the invoice and they couldn't raise the invoice in the name of return invoice. So they showed in their GST or in the tax invoices saying that we are selling these products back.
What is D8 to D33?
D8 to D33 are invoices.
Invoices?
Invoices from our carpenters and who are the customers who had bought the materials from us.
They have returned it back to you?
They have returned it back.
Okay. How much worth was the material?
Lord, altogether, we have suffered somewhere around 6 lakh rupees of loss, my lord.
You say 10 lakhs.
10 lakhs is the amount which is being disputed, the purchase we had bought from the respondent.
That's right. That invoice is worth 10 lakhs. Okay. How much is the liability? 57 lakhs.
57 lakhs.
47 in any case has to be paid.
Yes, my lord. That has been deposited, my lord.
Does not disclose that these tax invoices are raised for return of the goods. We'll call for the trial court record, I think. We will see it. Let the TCR be requisitioned before the next date of it.
The admitted amount may be released.
That, shall we release 47 lakhs?
I'll file my objections with respect to that, my lord.
Lashma Kenley,
No, my lord,
the
because
paragraph 20,
I
there is
sought
clear
for the
finding.
instruction from a senior
Yeah,
also. He
How
told
much
me
you
that
have
get
how much you have deposited?
75% of the decreed amount.
52 lakhs they have deposited. The 50 lakh is, there is no dispute with respect to the
We'll
50
call for
lakhs.
that, decide it. Just decide it. Just
Yeah,
have
at
it.
least, my lord, the entire amount is held up, my lord, is on loan, he is running. At least some amount may be
How
released.
much we will release it? 40 lakhs.
Yes, my lord. 40 lakh.
Huh?
My lord, they have.
Yeah, we release it. That's an undisputed amount.
It's an undisputed amount, my lord. With respect to 40 lakhs, it's undisputed. But whereas we have deposited 59 lakhs 33,000 rupees.
So rest would be here.
Yes, my lord.
Okay.
Undisputed amount, yes.
It's not, we will not say undisputed. We will say 40 lakhs will be released to him.
Yes, ma'am.
This is an IA 1 of 24 filed by the respondent herein. for the release of the amount as deposited by the appellants in this appeal to stop the learned counsel for the appellants has no objection if though an amount of 59,03,520 has been deposited, comma, and an amount of 40 lakhs be released in favor of the respondent herein. Just noting the submission made by the learned counsel for the respondent, we deem it appropriate to release an amount of rupees. We deem it appropriate to direct the, where is it deposited?
In the trial court, my lord.
Trial court?
For the trial.
No, then you'll do one thing. Ma'am, just show us.
No, it is kept in FD, my lord.
The notings. It won't be here. Oh, you have deposited in the trial court?
Yes, ma'am.
This order was passed here by this court.
Yes, ma'am.
Deposit.
It was passed by this honorable.
Deposit accordingly, the said amount having been deposited before the trial court in view of the order passed by this court on 11/6/24. We direct the trial court to release an amount of 40 lakhs to the representative of the respondent upon due identification and in the presence of the counsel for the respondent. Okay. Within 2 weeks from today. Yeah, don't say time. Full stop. Full stop. The trial court record be requisitioned before the next date of hearing.
Date.
Just give a date, no?
16/4.
Have you checked up the amount has been
Yeah,
deposited?
it is deposited. It has been deposited. I've got the order copy.
Full stop. Just say this. We also note that even the counsel for the respondent
Certified copies.
has, agrees with the counsel for the appellant that an amount of 59,33,520 has been deposited before the trial court. In this regard, he has drawn our attention to order dated 26/7/2024, passed by the Seristadar Accounts,
Right.
City Civil Court, Bangalore.
Executing court in 251 of 24. There,
Okay,
executing court in execution 251 of 24.
just say that before the
Trial court.
executing court being court number
83. At commercial court 83.
What is this 20?
Execution number 251 of 24, my lord. EP number.
In execution petition number X 251 com.x 25/251/2020. What is the date now? Before the executing court?
Date next month is the, it is, because of this stay, it is stay. The person is not going.
Okay. Stay of the
decree is granted.
Because of the execution. Okay. We'll just keep it, this order.
Well, memo.
No, just give a photocopy of this.
Yes,
Just give it to the court office.
I'll get.
Just list. Yeah, give it in March, April.
16/4.
Next. Mhm.
ಈ ಬರ್ತಾರೆ
What is-
ಆಫೀಸಿಗೆ ಬರ್ತಿದಂಗೆನೆ ಹೇಳೋಣ ಸರ್ ಇಲ್ಲಿಂದಾನೆ
And we are calling TCR from the file code.
That is different.
No, the file would be different. Yes. Decree file is different, execution is different.
Serial number 29. 29, Srimati Nidhishri for the appellant.
What were the submissions on the last date, ma'am, on this?
My lord, this was the matter where the appellant was placed ex parte. The appellant had appeared before the High Court in a CMP, and it was my contention that the change in address was indicated in the verifying affidavit, but admittedly, no separate application or intimation was given to the respondent or before this honorable court at the time of filing the CMP. Then after the CMP was allowed, there was an order saying that the two grounds that that the appellant had taken in respect of limitation and whether specific performance could be granted at this point in time, since the arbitration was initiated after 17 years, had to be considered. So the Honorable High Court had appointed the arbitrator and saying the arbitrator will look into the aspect of limitation, etc. In the arbitration center, of course, the same address was given. And what had happened then was they had carried out substituted service in a Kannada newspaper. And then ex parte award was passed. Section 34 came before the court below, and Section 34 was dismissed. So that has transpired so far, my lord. And we had, I'd taken my
You
lord.
are against 34.
Yes. I'd taken my lords to the order.
What is the ground?
Yes, my lord. The grounds that I'm raising essentially are under 34(2)(a)(1), which is the party was under incapacity since they were unable to, the address was not available, or rather the respondent did not give the right address. So that was one. And the other one was 2(a)(2), my lord, where we say that the arbitration agreement could not have been enforced, largely because it was, the agreement itself was barred by limitation. Since the sale agreement that was entered into was in 1999, there has been no communication from 1999 till 2015 when some legal notice was issued.
But how do you say now the court has appointed the arbitrator?
Yes, ma'am. The court has appointed the
But
arbitrator.
you were there before that court?
There again, my, the appellant's telephone number was given by the respondent, and then the appellant was before the honorable court.
But all the contentions were left open.
All the contentions left open, my lord. If my lords permit me, I'll take my lords through the order. I'll just go through two other grounds I'm raising, and then I'll take my lords through the papers. The other ground that I'm raising is that we were not given proper notice of the arbitral proceeding, and hence we were unable to present our case, my lord. And 2(b)(2), where the award is in conflict with the public policy, there's patent illegality in the order, since admittedly on the face of it, irrespective of whether the appellant was present before the arbitral tribunal or not, the first ground with regard to whether that petition, the claimed statement was actually maintainable, was something that the arbitral tribunal should have looked at.
The ground of limitation.
Yes, my lord, because what the arbitral tribunal says is that since the sale agreement does not have any contemplation with regard to the time stipulation, time is not the essence of the contract. Hence, there is no time bar.
So what are the facts here? It was basically agreement to sell.
Yes, my lord. It was an agreement to sell. I'll just quickly
And
take.
any time period prescribed?
No, my lord. Time period was not prescribed, but there were conditions where the sale consideration had to be paid, my lord. The sale agreement was entered into on 2/11/1998. And the total sale consideration was 1.67 lakhs, 1,67,000, where 1,40,000 lakhs had to be paid before signing of the agreement on 2/11/1998. However, and the balance of 27 was to be paid at the time of registration. However, only 1 lakh was paid prior to signing of the agreement. Balance was not paid. They did not even come forward. And it is also the contention that I've taken in 34 and before this honorable court that there has been no continuous readiness and willingness on the part of the respondent at any point in time. Other than even when we look at the arbitral award, the documents that have been produced are only the sale agreement in 1998 and the 2015 legal notice. Between 98 and 2015, there is no communication whatsoever.
Except legal notice.
Except legal notice, my lord. And that legal notice was also not served on the appellant hearing.
Because of the change of address.
Because of the change of address, my lord. So the same address has been used from 2015 for a legal notice, CMP, section 34. And again, we got to know.
By them?
By them, my lord.
Same notice, same address.
Same address even for the execution petition.
But that was the change address of yours?
No, my lord. That was the first address in 1998, 17 years ago.
But how would that help you then?
My lord.
See, you have not given the latest. They will go by whatever the address in the records.
Yes, my lord. But with due respect, when I had filed my affidavit, I agree, my lord, my client did not file.
It's a very far-fetched argument.
My lord, the address was there in the verifying affidavit, my lord.
Oh, he will not see everything.
Not to the court, my lord, to the respondent. The respondent should have taken due diligence.
I think better would be you should argue limitation.
I will, my lord. I
Limitation
will take my lords through the
When was the date of agreement?
2/11/1998. I've produced the agreement also before this honorable court.
And any time prescribed for the compliance or the executing the agreement, everything in the agreement?
Yes, my lord. If I could take my lords to the sale
Yeah,
agreement. Page
just
100.
come to that arbitrator's finding on that.
Yes, ma'am. My lords will find the award at 93 and the relevant portion, my lord, this is with regard to the limitation. The relevant finding with regard to the limitation starts at 13 and 14, my lord, page 100.
They are all served, they are not represented.
They're not represented, my lord. And the unique part about this is they're appearing before the executing court. And they've in fact filed a memo on the last date. This was on 4th January. I've produced, I have it.
Here or there?
There, my lord, in the
Saying?
executing court, stating that we have no right to challenge the, raise any objections in the execution since the order is not stayed and they don't say anything about the appeal that is pending. And when we try to serve the copy of the appeal, the counsel unfortunately says that he's not representing them in the High Court. So, and this is all that they have. This is the only address that they have of the respondents.
Okay.
Page 100, my lord.
Paragraph
13. First they say with if from the bottom, if it's about 6 lines is taken, my lord, where it starts with finally with regard. Finally, with regard to the point of limitation, the Honorable High Court of Karnataka and the said CMP has observed, in view of taking note of sequences of the proceedings and the agitation of dispute insofar as the aspect relating to the petition under section 11 of the Act, it cannot be said that the petitioner had lodged a stale claim before the court and issue of limitation is required to be considered by the arbitrator. It is true that the agreement is dated 2/11/1998. Legal notice was issued on 18/2/2015 to the respondents. In the agreement of sale exhibit P2, there is no clause with regard to the time for performance of the agreement. Clause 3 of the agreement says that if the purchaser committed default to pay balance of sale price, etc. on the due dates, then the respondents shall give a notice by registered post by acknowledgement due to the purchaser, etc. Therefore, there is no time limit fixed in the agreement. From this, it can be gathered, time is not the essence of contract. Apart from this, the claimants have stated that from the inception of agreement, they were ready and willing to perform their part of agreement and requested the respondents to receive the balance of sale consideration and execute the sale deed. Therefore, it can be held that the claimants was ready and willing to perform their part of contract from the inception of the agreement. As the said evidence of the claimants remains unchallenged and undisputed, I have no other option except to accept the claim statement and also the evidence adduced on behalf of the claimants and the documents relied by them. If I could trouble my lords to kindly turn to page 104 to see the exhibits that have been referred to, that have been relied on by the claimant respondent.
So you were not there now before the arbitrator.
I was not there before the arbitrator. I only got to know of the award when the executing court peon called the appellant and said this summons is pending.
Say 98, if there is no period for performance, it would be treated maximum very well. You will wait for 3 years
Yes,
for the
my lord.
performance and then come back.
Yes, my lord. So this is beyond 3 years. This is 17 years. There has been no claim made whatsoever seeking specific performance. And after 17 years, the honorable arbitrator has allowed the claim, said yes, specific performance must be granted, and also says receive the balance sale consideration.
It has to be on that only. Now, what happened before the executing court?
My lord, before the executing court, we have entered appearance. We've pointed out that there is an appeal that is pending.
But no further orders passed
No further orders have been passed. They are trying to serve the other respondents, my lord.
in that.
In that, yes, my lord.
Whether this agreement coupled with possession or not?
Not with possession, my
No, you are not given possession.
lord. Yes, my lord. No possession was given under the agreement. It was just a sale agreement without
You're in
possession.
possession now.
Possession is with the appellant, my lord.
And when is the execution?
20th February, my lord. I'm not mistaken.
It's surprising they don't appear. That's better. What are the orders passed in this? Is the TCI here?
My lord, the execution is on 1st of February. I stand corrected.
Pardon?
1st of February is the next date of the execution.
Respondent number 4 served again?
Yes, my lord. All the respondents are served.
No, but we said for 21, 2025.
Yes, my
They
lord.
have
We
been
took
served?
steps again. Yes, my lord. We took steps again.
4 served, man. Where is your stay application?
My lords will find that at page 117, my lord.
There is no consideration of the stay application, no?
No, my lord. Because at that time, the court was of the opinion that notice may be issued and once they come on record, it will be considered, my lord.
Just say this, no one appears, none appears for the respondents, those served. Stop. How many? There are 9 respondents?
Yes, my lord. Out of which the contesting respondents are respondents 1 to 5, my lord.
1 to 5.
The submission of learner counsel for the appellant is that that though the would submit that that though the appellants were not served, yeah, just say this, would submit that even if the appellants were proceeded ex parte by the learned arbitrator, comma, the claims which have been awarded, the claim petition seeking of the respondent number, claim was by whom?
By respondent 1 to 5, my lord.
1 to 5, which has been for specific performance,
Yes, ma'am.
which has been allowed by the learned arbitrator, was clearly barred by time, in as much as the specific performance was sought of an agreement which was executed on
2/11/1998.
2/11/1998. That too, in the year 1990,
2015.
2015. Full stop. The reasoning given by the learned arbitrator is totally perverse. She also states that the court below has simply rejected the challenge made by the appellants herein to the award without considering in proper perspective the case set up by the appellants in petition under section 34 of the Arbitration and Conciliation Act. We have been informed that the execution proceedings initiated by the respondents 1 to 5 are listed on 1st of February 2025. If that be so, as the respondents are not appearing in these proceedings despite service, and also we have we have been informed that they are pursuing the execution proceedings.
Yes,
We deem it appropriate to stay the execution proceedings being, what is the petition number?
execution petition number 3260 of 2018.
3260 of 2018.
18,
Before the court, which court?
before the court of the 31st Additional City Civil and Sessions Judge.
Just 31st Additional Cities. City Civil and Sessions Judge, Bengaluru, till the next date of hearing. Till the next date of hearing.
Deeply obliged. 24. Bill number 30. Bill number 30.
Wait, please. This 30 and 31, not I wish to appear for the appellant, Lord. These are fresh
Yes, Mr.
appeals
Mehta.
that have come up. Lord, these are fresh appeals filed under section 37 of the Arbitration and Conciliation Act.
Yes.
The order impugned by the section 34 court dismisses my objection not on merits, but on the ground of jurisdiction, saying that Bangalore court did not have jurisdiction, as according to the 34 court, the seat was in Chennai. And that's with great respect, not a completely wrong conclusion in my respectful submission. Rushes have yet to issue.
But
Yes,
11
Lord.
will not have a bearing on the 42.
11, I'm sorry, that's my argument, Lord. That is my argument. The section 34 court proceeds largely on the reasoning that because section 11 petition was filed before the Chennai High Court, and therefore Chennai would be the seat of arbitration. Of course, it has also relied upon other aspects, and none of.
But tell us any judgment on 11 having a
Not can matter.
having a bearing
Rushes
on
are yet to
42.
issue notice in my. Yes, it's a point. In fact, I have a short 2-pager. I hope my instructing counsel is carrying for the court a short 2-pager. This issue is not res integra. Section 11 court is not a court with respect to 42.
Section 11.
This has been decided by several judgments.
The seat of arbitration is Bangalore.
According to me, the seat of arbitration is Bangalore. 34 court says, well, Bangalore is only a venue, not a seat, and therefore I can't challenge the award here. Whereas,
Let's see that arbitration clause.
yes, absolutely. Please kindly come to the additional documents.
Where are the additional documents? Have you filed it?
I will file additional documents. Now you are giving.
See, you should file it in advance.
I'm sorry, but I was told that it has been filed. Nevertheless, the arbitration clause is extracted in the section 34 order also. But if you losses have the additional documents in front of you, I can take your losses through the additional document.
The venue of arbitration shall be Bangalore or any place which the arbitrator may choose. But in the additional documents, Your Lordship would find the arbitration clause at page 9. Kindly come to page 9, my lord.
Judgments.
The parties are based in Bangalore.
Parties are all based in Bangalore. The entirety of work was carried out in Karnataka. Chennai has no connection except section 11.
Why did they go to Chennai for 11?
My lord, section 11 came to be filed in Chennai. My lord, there is no explanation for that. But assuming that to be a factor, that can't be a factor determining the seat court at all. The Supreme Court says that. Please have the arbitration clause, not at internal page 9.
This notice issued on this. Huh?
Notice has not been issued, not. This comes up not as a fresh appeal. It was listed previously, but on occasions it couldn't reach.
Issue notice. Issue notice. Both. You appear in the other matter also?
Yes, not both 30 and 31.
Just give them back. File it, e-filing.
I'm sorry for the inconvenience, not. It will be. The instructing counsel should have filed it. Not. I'm sorry for the inconvenience.
Let the additional documents be filed through e-filing. Within 2 weeks, full stop. Issue notice to the respondent, returnable on.
I also have a short note of submissions.
You can give us next day after notice is served. Let them come.
Very well. If it could be on a short date, I'll be most grateful, Lord.
Just give it March.
Because I've been stumped only on the issue of limitation. 34 court hasn't gone into the merits.
24/3.
Grateful. What
So
about judgment, my lordship? Judgments are there.
File it there, everything.
File it in the counter.
Additional documents / the judgments be filed through e-file.
So deeply obliged. Most grateful, Lord.
Next.
Serial number 36. 36.
Respondent number 22 in this matter, Lords.
Kind permission, my lord, to better understand the case, my lord. Just I will pass on a sketch, my lord, so that the argument can be curtailed. Copy. My lord, the 22nd respondent, my lord. Rough sketch, my lord.
What is this?
My lord, the yellow portion, my lord, survey number 145, that is 3 acres, 146, 3 acres. These extents, my lord, was granted in favor of certain grantees. The 22nd respondent has purchased these 3 acres and 3 acres. That is totally 6 acres. He has purchased under the sale deed wide action B, B1 and B2. He applied for conversion. He applied for conversion to an extent of 13 acres and 36 untas. On the ground that the red portion, which is attached to yellow portion, is alleged to be a Karab land. My lord, such a huge extent of land cannot be a Karab land along with this the grant which has been made. Then on the basis of the conversion of land, my lord, he filed a writ petition before this honorable court. This honorable court, my lord, directed to durust the land in question. As per Annex E, my lord, and since the durust was not committed, he filed a contempt petition before this honorable court. While in order to comply that order, my lord, as per Annex E, the durust has been effected. Then, my lord, the commissioner is of the opinion, my lord, that there are no virgin records are available. And therefore, my lord, a suo motu proceedings was initiated under section 56 of the Land Revenue Act. May kindly see page 74 of the order, wide Annex E, my lord, page 74. In respect of the code which has been done in favor of the 22nd respondent, at page 74, my lord, last para 6. Got it, my lord? Survey number 145, 146 in village Kudregere, Jala Hobli, Elanka Taluk, so and so. In Sagode Chits issue register in Taluk office, the extent of land granted recorded is 3 acres each to Srimati Subbamma and Sri Krishnappa, and this is total extent of 6 acres. But Tippan was created for 13 acres, 36 guntas, 7 acres for survey number 145, and 6 acres, 36 guntas for survey number 146. The additional extent of 7 acres, 36 guntas added to Tippan is outright illegal and caused a loss to government about rupees 50 crores. Respondent 5 purchased the land to an extent of 3 acres
each from successes and purchases from these original grantees. Hence, on this ground also getting tippened for survey number 145 and 146 for 13 acres that is task is unsustainable. The land grant file records are unavailable, but the response 1 and 2 did not follow the prescribed procedure of government circular number so and so, read with circular number so and so, created an illegal tippen. The missing file committee was not convened for passing the relevant orders on the grant claims of respondent 5. This makes the creation tippen for survey number 145, 146 totally illegal. Void order dated 23/8/2021 by Deputy Director of Land Records, Bengaluru Urban District so and so, therefore unsustainable. Further, in absence of tippen of granted land, the land conversion order under Section 95 Land Grant Revenue Act 1964 itself could not have been issued by the Assistant Commissioner in the year 2005-6. The land use conversion order under Section 95 KRR Act 1964 ought to be based on tippen and not the other way around. The whole procedure has been controverted by deliberately and illegally putting cart before the horse. Further, the RTC itself should be based on tippen and created under Darkhast Code. In this case, land use conversion order has been issued without tippen. Also, illegal conversion done in excess by 7 acres 36 untas than extent mentioned in land grant register. Respondent 5, instead of creating tippen as per land grant, has created it as per illegal conversion order. Hence, the order of so and so. Then, the impugned order at page 77. He has set aside all the duress and ordered for the measurement and redoing the duress. Then this order came to be challenged by the 22nd respondent. The learned single judge Malad has set aside on the ground that the duress has been done about 19 years back. Actually, duress in respect of Survey 146 were done in 2021 as per Annex G. The findings is at page 42. It is wrong. From got it, shall read Miller 42. After extracting the section, from the reading the above section, it is clear to this court that revenue officer or a survey officer referred to under subsection 1 of section 56 of Karnataka Land Revenue Act can initiate suo motu proceeding within 3 years from the date of the order sought to be revised. And if such power is to be exercised 19 years after the duress work, same has to be held as barred by time, and suo motu proceedings can be initiated exercising revision powers. Therefore, this court is of the opinion that Joint Director of Land Records, Bengaluru, has committed a serious error in invoking revision powers 19 years after the orders of the Deputy Director. Ashima Kelly's Annex G is 2001, not about 19 years back. Annex D is 2021, not about 19 years back. Therefore, my lad,
it is not 19 years back.
According to learned single judge, my lad, this duress has been done about 19 years back.
That's right.
But it was done in 2021 as per Annex E. In respect of survey number 145, page 132, my lad. The operative portion is at page 140. In respect of 145, 146, it was done in 2021. That too pursuant to the direction issued by the court and also in view of the contempt procedure.
You appear for whom?
My lords, I am appearing for the respondent number 22, my lords. I'll file my objections to this appeal, my lords. My lords,
What about the other respondents? Are they?
notice is not yet issued, my lords.
My lord, notice can be dispensed with, then my lord, it is only the writ petition has been
You are
filed by
the contesting
22nd
party.
respondent.
My lords, I am for appearing for
the
respondent
writ
number
petitioner.
22, my lords. I am the petitioner in the writ petition, my lords.
No, but tell us one thing.
Yes, my lords.
Now, others are relevant, important.
They are
others-
not relevant, my lord. Notice can be dispensed for respondents 8 to
It
21.
is,
Entire tippen, my lord, it was not done in accordance with law, my lord. That is the reason, my lord, the deputy.
Actually, government
the
should have
commissioner
preferred a writ appeal.
suo motu conducted these proceedings, my lord, and held that, my lord, an extent of 7 acres of land was lost to the government, my lord.
my lord, for which
Should have
the
preferred a
government itself issued a notice to me
And
seeking
that
a conversion
single
fee.
learned single judge, my lord, has not
But
given
he
any.
says you should have filed an appeal.
Yes, my lord, that is.
Even when there is findings, 50 crores
lord,
of
if I
half
may,
of
my
this
lord.
revenue.
Even
If I may, my lords.
Issue notice.
I'll file my objections to
Notice
this
to
appeal.
8 to 21 may kindly be dispensed, Mera. They are
Don't know. We'll say at your risk.
at my risk.
Notice, issue notice to learner counsel for the appellant submits that the notice be issued to the respondents 1 to 6.
No, 8 to 21.
1
Sir,
to
sir.
6 is the notice. In other words, the notice to, no, 1 to 7. In other words, notice to 8 to 21 be dispensed with at his risk, at the risk of the appellant. Just say that at the risk of the appellant. The noting the said submission, issue notice 1, 2, 3, 4, 5, 6, 7. Where is he?
No, I am the
22nd,
caveat.
22, serial number 22.
22, my lords. I appear for the respondent.
1 to 7, ma'am, she asks, accept notice. 22, so and so accept notice. For 22. Okay.
I have sought
The-
for injunction. That is not
I'll file my objections to the appeal, my lords. He doesn't have even, the appellant doesn't have locus only, my lords.
1 minute.
Yes, my
Was
lords.
he a party there before the learner
Yes,
signature?
I was a party.
Who, man?
He.
Yes, my lords. My lords.
1
In-
minute.
For which the single judge
The-
also held, my lords.
The objections be to the appeal be filed by 1 to 7 and 22
Yes.
within 4 weeks. Now, what do you have to say? Are you filing any contempt petition?
My lords, actually during the pendency of the writ petition, due to the interim order being violated by
Even
the
they-
state
they
itself.
have
Let
filed a
me,
contempt-
let
sorry,
me.
They have
if I
filed
may,
a
my
contempt
lords.
petition before this honorable court for implementation of this order. I think some order has been passed in that contempt petition.
No, my lords. In fact, on the day the order was being dictated, the appellant was before the contempt court and the appellant requested the contempt court, despite not being a party in the contempt proceedings, the appellant requested the contempt court that let my land also be, let the kata be transferred back to my name. And now the appellant comes before this court and makes such submissions, my lords. Hence, I may be permitted to file my
What
objection.
have you been granted by this impugned order?
My lords?
What have you been granted by this impugned order?
The
My lords, the
entire
writ petition came to be allowed, my lords.
proceedings
The
of the commissioner was set aside.
set aside, my lords.
In your favor?
Yes, my lords.
And what is this pay compensation of 5 lakhs?
My lord, that is pertaining to the connected writ petition, my lord, which is not before this court.
No, let's see your directions. Where are your directions?
Page 44, Madam. Page 43 and 44.
Now, to the extent of yours is which paragraph?
My lords, in fact, the observations are from. My lords, the
Your
observations are
direction
from
is in which
para
paragraph?
8.
Para 11.
From para 8 onwards, my lords.
But where are the directions, final directions?
My lords, the operative portion is at para 17, my lords.
Accordingly, 904622 is allowed.
Yes, my lords.
It is quashed. I am of the view that the petitioner has made out a case for interference. Impugned order is passed. This. So you have initiated execution?
My lords,
I
the
filed
contempt
contempt.
was pending, my lords. During
Contempt,
the
you have filed contempt?
contempt was pending and the contempt during the pendency of the contempt proceedings, my lord, the state has complied with the order of the contempt court, wherein the kata was supposed to be transferred back to my name, the RTC extracts. Accordingly, the state has carried out the compliance and the records stand in my name as of now, my lords.
That's
And in-
right.
Records are standing in his name.
So then what is the stay you are seeking?
My lord, not stay, my lord, not to take up any project in this matter. No, by virtue of conversion,
My lords,
they may sell this
my
property
lords, if I
also.
may, my
They
lords.
They
make
also
one
form the
submission.
layout. Suppose if the nature of the land itself is changed because they have obtained the conversion order. And if the layout is formed and the sites are formed and if it
So
is
you
sold.
will maintain status?
Yes.
No, my lord, no, my lord, if my lord goes by the submissions made by the appellant, the conversion order has already been challenged by the appellant before the KAT.
That
my
is
lords.
true. Yes, I have stated.
Let him go before the KAT court and
But was there
adjudicate
is
over
there
there.
any stay there?
There is no stay.
There is no stay. That is the reason, my lord. Let him adjudicate before the KAT.
Oh, you have challenged the conversion order, then you
Yes,
must
my
go
lords.
there, na?
There is no stay anywhere. He's come before this court.
See, tell us one thing. You are now, what you are seeking is pursuant to that conversion order. You have challenged the conversion order,
I have challenged.
then you must challenge there.
In
You
fact,
must seek the stay there.
in fact, it is challenged in the year
1
2017,
minute,
my lords.
today, just 1 minute. Today, strictly speaking, this order has been complied with by the state. They have converted into the khata. in the name of the.
Yes. But what happened, my lord? What happened by virtue of this order, my lord? Now, my lord, though they right only to an extent of 6 acres, 13 acres of land, they are going to form the layout. That is the reason, my lord. Suppose government land, it is the government land and government property has to be.
They have changed the khata also. We are surprised.
But it is wrong. It's wrong. Totally wrong. Totally wrong.
They don't get a stay in elsewhere. They come before
Even
the
there's a
court
finding
and press
just I
for a
have read
stay.
that.
Their grievance is before the appellate court. KAT, let them go before the KAT, Manoj.
Strictly speaking, you must go over there. Today, tell us one thing. What is being directed is the change of khata by the learner single judge.
No. Here, my lord, what the commissioner of land records wanted to do, my lord, to rest affecting the right to an extent of 13 acres is wrong and therefore redoing it. Therefore, there was a direction to create the new tippon and in respect of not only his land, his survey number, but also all survey numbers which has been done in respect of original survey number 55.
In fact,
The effect of
appellant has objected to that proceeding before the commissioner, Manoj. I'll take, Manoj.
Just 1 minute, let the council.
I might have done.
Yeah.
Sorry.
Yes.
My lord, originally survey number 55 measuring 105 acres. It's a government land. It has been granted in favor of various persons. Now, my lord, after granting, my lord, the new survey number has been done by effecting Durasta. Even there is a grant in my favor to an extent of 2 acres 32 guntas. My survey number has also been given as 152 now. By virtue of this order, my lord, since there are no original tippon and Durasta and other things, the commission has directed the deputy director of land records redo it by creating that new tippon in respect to original land, that sketch another thing, and redo it. It will therefore, my lord, by that order, my lord, what has to be done? The deputy director of land records has to remeasure the land and what is the land granted in favor of his vendor and others. That is the thing. Now, my lord, by virtue of this order, the order of deputy director affecting Duras to an extent of 13 acres, though he is not entitled, is confirmed. Now he is going to form a layout.
No, you're right. Layout based on a conversion order.
Conversion order, and also the title is here. Title is here.
Right. But today, tell us one thing. This direction in paragraph 17, following the judgment of the court and the apex court referred above, I am of the view respondent number 3 has committed an error in passing this, initiating suit against the petitioner without issuing notice to the aggrieved party, namely petitioner herein, and pass the impugned order unilaterally, interfering with the settled revenue and survey records after a lapse of decades. Therefore, I am of the view that the petitioner has made out a case for interfering. Accordingly, impugned order, this thing passed by the liable to be set aside, quashed. Okay, so
Yes.
he has set aside.
Set aside. There is no remand at all. Once if it is set aside, the effect is the order of putting his land to an extent of 13 acres is confirmed.
Manoj, the grievance is before the KAT. You should challenge it before that. In the year
That's one
2017,
thing, that's one thing. Let's kindly appreciate. Though he is not entitled for 13 acres, by virtue of the order of the learned single judge, the order of the earlier affecting Duras to an extent of 13 acres has been confirmed.
And the conversion land is with regard to,
Entire 13 acres.
Acha, entire 13 acres.
That order of, as on date of conversion, my lord, he did not have right to an extent of another 7 acres at all.
Records
After getting the conversion, he applied for creating the Duras. Though original records are not there, because of the
What he is arguing is conversion is one.
Yes.
Title is another.
Another thing.
Title is another.
Unless title is there, there cannot be an order of conversion.
For which, if he is questioning my title, the appellant has already preferred a suit in the year 2000.
Protect my land. I have protect. Yes.
In the year
I
have stated so.
2017.
No, your
suit
land
is
is 13
pending.
acres.
No. I am not claiming it.
There's no locus.
My land, the so-called acre of land is also attached to my land. If it is to be granted to him on the ground, it is adjacent to his land. I am also entitled for that land. It is also adjacent to acre of land. Why it should be given to him?
No, his is that you should not, now today, effectively by their action, you got the title.
Yes, my lord.
That's right. His endeavor is that title must not be changed. That's the
My
injunction.
lords, my lords, my lords, if I may, my lords, there is a, my lords, if I may,
In respect of a Kharab land,
A Kharab, 37 acres land.
Only in-
that should not be changed.
It should not be changed.
my lords, for which records may be called for which the government has only issued notice to me
See,
calling.
we are only saying we will not pass, you will say so, you will not change the insofar as that is concerned.
No, my lords. The appellant has initiated a suit stating that
The
I'm,
suit initiated.
sorry, my lords?
What is the suit
Root, my
initiated?
lord, since on the ground of this order, he is trying to encroach upon my land. Therefore, I filed
Yes.
suit.
That's a different argument. That's an injunction suit.
Yes,
Injunction suit in year 2017.
yes.
He's
different
filed an appeal before the land grabbing court, which is pending is what stated by him. There is an appeal, there is a matter before KAT challenging my conversion. There is no locus. In fact, my lords, the appellant has opposed the commissioner's order, my lords, if I may, my
We
lords.
have challenged the land, but now tell me land grabbing, what remains in land grabbing after this?
Yes, that
Lords,
is,
if I may, my
there
lords,
is a report by the Tahsildar before
Page
the
71.
land grabbing authority stating, my lord, he has encroached 7 acres of land. I have also produced this here.
Tell us.
my lords, page 71 of the appeal may be looked into, my lords. The appellant has opposed to the commissioner's proceedings, my lords, if I may, my lords.
You
Page number-
file your objections as fast as possible.
Yes, my lords, yes, my lords.
How much time, minimum time?
My lords, 2 weeks, my lords.
2 weeks.
Yes, my lords.
We'll have it after 2 weeks. Okay?
Lord, I have to check, my lord, whether the
At least
contempt
take-
proceedings
my lord-
were dropped, whether the contempt proceedings were dropped prior to the order passed by the Commissioner Survey and Settlement. my lord. Because contempt proceedings, contempt was
But
initiated.
contempt are not listed before us.
No, my lord,
My lords,
that is dropped.
It
my
has
lord.
been dropped, it has been disposed of, my lords.
No, you are right. For the reason they have complied with the order. That's all.
Yes, my lords.
See, you are not understanding two different things. Insofar as the direction is concerned, set aside the consequences, what their action they have taken.
Yes, my lord.
Now, he has come with the appeal saying that this order which has been passed by the learned single judge is incorrect.
I'll file my objection.
See, once he says, according to him, once he says there is a violation of principles of natural justice, it should have been remanded back. That's right?
Yes, ma'am.
Should have been remanded back.
It has been,
Notice,
it has
sir.
been set aside not only on the ground of principles of.
We will hear you.
Yes, my lords.
File your, we'll
Yes,
have it, just give it in second or third week of February. File your rejoinder by 1 week. Rejoinder, you file it 1 week.
18-2.
In fact, it is a case where state had to, ought to
Obviously.
have preferred appeal, my lord.
But
That being the case, the state should have opposed the contempt proceeding, my lords.
Even contempt, my lord, they.
You have
should
implemented
upheld
the order also. Next,
40,
Obliged, my lords.
40, Shenar Naik. Shenar Naik. 40.
just give it back, just give it to me.
Madam. Madam.
ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ
Call her.
ಅವ್ರ
40, remember 40?
Apology, my lord wanted to come, say something.
No,
Serial number 40.
none for the parties adjourned to. Who appears in 40?
Shenar Naik.
Then, next man,
60.
50.
60, sir, 60.
60.
Sorry.
44.
46, sir, 46,
44 Unnikrishnan date hoಯ್ತು.
44.
And 46, we also. My lords, my senior is still on his legs before the Delhi High Court, my lords. 46, have we not adjourned? No. Let
there
My-
be a
my
stay of
senior
those
still-
proceedings, my lord.
No, my lords. My only request is the matter may be had tomorrow and it can be taken up at length, my lord. Either which way, my lord. My senior continues to remain on his legs before the Delhi High Court. He's appearing through VC, my lords. What do you say? Will I have it? Just say that though a passover was sought in the first round on behalf of the counsel for the respondent. From what we have been informed, he's still on his legs in another court. Adjourned to, when do you want? Just give
So the
it.
execution
Tomorrow
is
is
on
fine, my
10th of
lords.
February.
What?
The execution proceedings is on 10th of February. I'd like to argue on
Before
that.
10th February.
Please,
Tomorrow, my lords. Tomorrow.
see it.
Yes,
6-2,
Grateful.
much of this.
serial number 18.
For the petitioner melons. Once it may be taken up anytime next week.
My lord, I was held up in some other court,
15, huh?
18. And both the parties have filed the statement, stating that exactly what is the amount,
Manmohan was here.
including GST and excluding GST.
What do you say, ma'am?
The filing the memo of. clarification.
Not here. You will file it in e-filing.
I'll file it. May be taken up anytime next week, my lords.
You'll see it. Just say that at the request of counsel for the appellant, adjourn to. You will file it e-filing.
Please.
That's all.
18.
This one. Very much.
Court officer? Court officer?
Sir, ಹೇಳಿ sir.
Serial number 50 ಏನಾಯ್ತಮ್ಮ?
50, 50.
50, last one.
22-4.
Madam?
22-4.
22-4 ಹೋಯ್ತಾ? ಏನ್ ಬೆಳಿಗ್ಗೆ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡಿದಾರಾ?
ಇಲ್ಲ ಸರ್, ಕಾಲ್ ಔಟ್ ಆದಾಗ.
ಆಯ್ತು. 22-4ಗೆ?
ಹೌದು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮಾ.